No.
It's all up here. It's all up here.
Just a highlight.
Thank you.
Yes, I did. Yeah, I had a holiday in May on Perth. About 6 hours these days. It depends about on the jet stream, about 6 or 7 hours these days in the new plane. That's the time when I'm waiting up my
I'm going to give this to you. Oh, yeah. Perfect, thank you.
Was it? Yes, I thought that you were 15 minutes. I thought, oh, it's taking a long time. Oh, no.
Just informers.
Oh, right.
Trouble?
How are you? Yeah. At least a couple of days. Exactly. It's all right. Yeah, you tried it. Yeah, 2 flights in the last one. That's right. But that's a bit biased. The red light opposite. Yeah, he seems to be pretty good. Yeah, he's doing great. Yeah.
Hello! I'm a little... It is quite hot. Strode up the hill. Can we keep me company? Before I got it.
Oh, really? Okay.
I don't know what to do. I didn't know your texts. I assume you didn't answer your text.
Don't worry, I don't think personally. Is there something I don't know?
Well, we're trying to close through the issues. And I was slightly perturbed.
London.
Have you got people coming?
One. Yeah, she. Dresses maybe half of them.
Probably read because we RSVP. Drag it up. Yeah.
Tom's going to text. We're here.
Sorry. You done that?
Yeah. I think it's smart.
Yeah, thank you. It's actually low.
Yeah, good. How are you?
Low, thanks to you.
Good. Yeah, not bad.
Yeah.
Yes.
Yeah.
I'm sorry, is this your seat? Welcome.
You better? Oh, I just got a cough that won't go away. I cough around the nose. Just, I feel fine. I'm just.
Yeah.
Sorry, I'm going to leave.
Oh, sorry.
No, it's fine.
I have that effect on people. I hope I don't. No problem. Hi, how are you going?
Waste that long.
I'm getting closer. Just retirement getting closer.
I know it's going on to them. It's the right thing to do.
Thank you.
Such a gentleman.
John Phil Mitchell. Yeah. When you fit in yes. Oh, right, okay. So, TTR with a plan technical team. So,
More enough.
I don't think we've got a lot to do here through, but
Cool. We're waiting for it.
sorry.
Who gives advice on one?
Well, that's why you got back here.
I read this.
Good morning, yes, I can. Thank you.
Can you hear me, Mr. Enright?
Yes, thank you, I can.
I just wanted to let you know there's going to be a delay of about 10 minutes before we start.
Oh, thank you for that. I'll turn the camera off in that case. You don't have to stare at my visage. Thank you.
Thank you.
Can you work with me?
It's good for you. We did see you. We waved to you. It'll keep on going. Just throw it out there and then just not come. We've got Natasha. She loves a good condition.
Oh, I see. Oh, okay. Sorry.
Do you think I could? Would it be
I know he was straight after us. He was because me and Rich were there for Forest and Bird, and then so you finished, and then he showed up and said, looks for me, and with Sarah Shaw.
Right, smile. Thank you.
It's oh yeah, it's very good. They were in the front row, I reckon. It's a Cameron Luxton. He was the guy. I thought he was national. So he said to us, "Don't you want a competition in the supermarket industry?" That's not. If you're not listening to everything that we see. Yeah, that's right. Yeah.
That's like, okay. And then so they didn't bring cake. And then obviously told me. She walked in. See what she
All right, ladies and gentlemen, and Mr. Enright online, We'll begin with a karakia, and Haimona has come all the way from Taranaki to do that for us. Could you do that now, Haimona, please?
Tēnā koe o tira tēnā tātou, aroha mai mo te tōmuri nei, taku whakapāha nei ki te kaupapa. Ui anō kia pau mauri ora, ki ngā te whātua tau kainga i mihiana, kia tauwhironga manakitanga o te wai ngaro ki ringa ki tēnā o tātou. Kia rihi pai mai kia tātou kōtau o wānanga o tēnā o tātou. Turu o whiti whakamaua, kia tīna, hui e, tīna.
Well, morena koutou, welcome to you all. Thank you for joining us. I'm Kit Tuggood, chair of the panel. On my right, Loretta Lovell. On my left, Gavin Kemble, also members of the panel. Behind us, although somewhat obscured by me particularly, I suspect, on your right, Sally Jett KC, who's our legal advisor, and on your left, Carolyn Ratt, who's been appointed by the EPA to assist us with the preparation of our decision. And I also want to introduce Kili Pela and Tu Fiwani from the EPA, with whom I imagine you have dealt from time to time. Would Council and representatives present please be good enough to announce their appearances, just so that we can get that on the record? We'll start with the front. Justine, would you like to start?
Tēnā koe te kai whakawāme ngā mema tātou e hui mai nei. Council's name is Justine, and it's for these purposes. Thank you all. For Ngāti Ruanui.
Go up one side and up the other.
Good morning, my name is Peter Anson. I represent Forest and Bed with my friend Miss Downing.
Thank you.
Raurangatira mā tēnā koutou o tira tēnā tātou, Ms Ernesto and Ms Murfitt for Te Oru Kaimana Trustee Limited.
Tēnā koe te kai whakua, koe tomo hau, he roia mō Ngāti Manihiakai, ka nehi e okahu hapu o ngā ruhi. Kia ora.
Tēnā koutou, Council's name is Conway. I appear with Ms Parker for Taranaki Regional Council and South Taranaki District Council. With me, Mr Kittle and Mr Kylan McKean, also representing those councils, and not as council.
Can you speak up, please, because it's quite hard to hear from you from down here. When you're addressing us, we might have microphones, but while you're introducing yourselves, you can speak right up so we can hear you.
Apologies, sir. Would you like me to repeat that?
No, we got the message.
Thank you.
Conway.
Tēnā koutou, Ms Hazen, appearing with Ms Curry for Chasm Agreements.
Thank you, Ms Hazen.
Kei te whānara tēnā koutou, o tia tuki a koe, e te rangatira Māui whakarite tō tātou huhunga tēnā koe. Paranihia Walker and Rihanna Mora appearing for Te Kāhui o Rauru. We also had instructions in the last couple of days to also appear for Te Korowai o Ngā Ruahine, so thank you.
Ki te kai whakawā, hui ngā mema o te Paipiri, tēnā koutou, o Jamie Ferguson Takawangoa, I appear for Te Tōpuni Ngā Ruahine.
Good morning, Mr Commissaris here for Environmental Defence Society with Mr Enright online.
Mr Gardner.
Yes, Marina koutou, Gardner Hopkins here as representative for Ngāti Manihiakai and Ngāti Tu.
Kia ora koutou, my name is Slyfield. I appear for TTR along with Ms Buxida. We also have present Drs Mitchell and Diarmid and Mr Eggers.
Good morning all, thank you very much. Thank you, I'm grateful to you. I just want to tell you briefly something about the timetable. I think Keely may have told you basically what we had intended, although it's fairly flexible for reasons which will become apparent in just a moment. We thought we'd take morning tea around 10:45, with an hour lunch for half an hour at 1, afternoon tea at 3:15, and then we would finish the day at 5. That was the plan. But we are very grateful to you all for your efforts in responding at short notice to our questions on legal issues. And I have to say we've been impressed by the quality of your submissions, by the focus which we asked for, so that they're succinct, but they are very understandable, and it's made our job so much easier. We're also very grateful to those council who gathered their thoughts and provided that helpful memorandum of the 24th of November and the attached schedule. Those have both proved very useful tools for us, so thank you for that. The members of the panel who are present and our advisors have spent quite a bit of time considering the legal submissions, discussing them. And as I say, we found the quality excellent, and that has meant that as we worked through them yesterday in particular, we found that we did not have as many follow-up questions for you as we anticipated we might have. But we have identified some, and we'll direct specific questions to council or representatives for specific parties accordingly. But it may not take, in fact it will not take as long as we thought it might take us. But we value this opportunity to have you with us in person and Mr. Enright online, and we acknowledge that this is a good opportunity to hear from you on what are some quite tricky legal issues. We are conscious, among other things, that the submissions were filed simultaneously, and therefore there may have been aspects of submissions filed on behalf of other parties, some whose views you may support, some whose views you may disagree with. And we thought we would give you an opportunity to speak to those if you want to do that. The other point is that Ms. Lovell has a question, what she describes, I think, as the second part to question 10, which on our observation wasn't directly addressed by any of the submitters, and we'd like to hear from you on that question. And I'll ask her to explain that now, so that you can give it some thought. But then we'll give you some time when we've finished asking our questions to gather your thoughts. You can take an hour or whatever it is you need to think about what other submissions you want to make, or simply to take us to the main points of your submissions. We don't want you to go back through your submissions in any detail, but we would have a couple of hours or so available to you to make any additional submissions that you want to make arising out of the questions and answers that have been given this morning, or any other matters related to those submissions. And we will do that, Mr. Slyfield and Ms. Buxeda, first hearing from the commentators and then giving you an opportunity to respond. So we will use the time usefully in that way, and I hope that's acceptable to you. So, do you want to just talk about the issue that you wanted to deal with? Yeah.
Kia ora. Kia ora koutou. So yes, in minute 11, for this hearing, the panel asked two aligned questions at question 10. As you know, the first part was the relevance of the treaty principles, cultural values and kaitiakitanga to the panel's considerations and when they fit within our assessment framework. There was a second question which was of note, which is in particular, what is the correct legal test to distinguish an effect on an existing interest as defined and used in the EZ Act from an effect on an obligation arising under a treaty settlement under the Fast Track Act, Section 7 and 1A. I note that this really wasn't picked up in terms of detail with respect to the joint memorandum or with respect to the written submissions. It was alluded to, but I think for the panel's purposes, we consider that it would be of assistance if we received oral submissions directed specifically to that second part of question 10. Again, namely that the correct legal test for distinguishing between an effect on an existing interest under the EEZ Act and an effect on an obligation arising under a treaty settlement under Section 7(1)(a) of the Fast Track Act. So again, we suggest that parties take a moment after our questioning and consider how you can respond to that question from us, and that would be appreciated. Kia ora koutou.
All right, let's get straight on to it. My first question is question 2A, which reads, is the panel required to determine whether TTR's proposal requires approval under the Resource Management Act? And my question is directed to TTR, so Mr. Slyfield, Ms. Baxida, I don't mind which of you responds, but the position you have taken in the application is that you don't require any resource management consents. But we noted that in the part 1 of the SICAP report, at page 168 of the SICAP report, and you may not have it in front of you, so I'll read you the passage just to refresh your memories about that. The report reads, even though this relates to the mooring of buoys for monitoring purposes, even though the specific details have not been confirmed as to the mooring configuration and surface buoy arrangement, TTR is aware that a coastal permit, likely to be a discretionary occupational consent, will be required from the Taranaki Regional Council prior to the BEMP commencing. A resource consent application and supporting assessment of environmental effects will be submitted to the TRC for processing as soon as the relevant mooring and buoy details are confirmed. TTR note that the application for the placement of the moorings and surface buoys will be submitted in accordance with the relevant rules of Regional Coastal Plan for Taranaki in adherence to the RMA 1991. No moorings will be placed within the CMA without prior resource consent approval. So my question really, and I know that may appear to be, and it may be, a relatively minor issue, but is that not a consent application that has not yet been made that is required to be made and is a discretionary consent, and there may be others of that kind that will affect the project?
Thank you. And I don't have a light on, but I'm assuming you can hear me okay through the microphone.
Thank you.
Perhaps it's useful if I start by saying TTR's position is that the statement you've referred to in the CCAP report is accurate, and to that extent, yes, there will be a requirement for resource consents, as TTR understands it, for those moorings, and that has not yet been sought.
All right, well, there's a follow-up question which I'm going to ask you about that, but I'll come back to it after I've heard from Mr. Enright. Thank you, Mr. Slyfield. So, Mr. Enright, just on this issue of the need to apply for other resource consents, you have said at paragraph 8 that TTR will require one or more resource consents under section 12(1)(d) of the RMA, And you're referring there to circumstances where discharged sand migrates from the point of release in the EEZ onto the seabed or the foreshore of the coastal marine area and causes an adverse effect. As I understand it, you're referring there to the deposition of sand back onto the seabed in the permit area, but suggesting that sediment will carry into the coastal marine area. So first, if I'm right about that, your submission is that that proposal therefore would require a consent under the RMA. And you go on to say that on balance, EDS admits that the Act does not require the panel to determine whether the proposal requires approval under the RMA, and nor is TTR required to seek all necessary approvals for the proposal. But your point is, on behalf of EDS, that the applicant bears the risk that the proposal will not be able to legally proceed if resource consents under the RMA are required that have not been sought and granted. And you say then that the panel may, as a matter of discretion, have regard to the need for additional RMA consents as relevant to the question of immediacy of claimed net benefits. And this is the particular point I want you to focus on. You submit that given these are contingent on securing additional RMA consents, this means that the benefits are not capable of being secured, and that may affect their net value. So my question is, does the contingency issue, that is the security of additional consents, affect the benefits and the costs or disbenefits of the action equally? That is, if the consents are not secured, neither the benefits nor the costs or disbenefits are experienced. And are there specific costs or disbenefits that could be experienced without realising the benefits? And that relates, of course, to unconsented activity. Are you able to comment on that for us, please?
Just before I answer, the context to this is set out in a joint memorandum that's dated April 2014, and I believe we've provided that too, but certainly Mr. Commissaris will make sure that's the case. And the example given as between both EDS at the time and Council then acting for TTR was of deored sand migration from the point of release in the EEZ to the seabed or foreshore of the CMA and resulting in an adverse effect. And that would be captured by, on EDS's position, I should say, that would be captured by Section 12 as a discharge under the RMA. And the example given related to the discharge of faecal matter from marine farms, which often migrates a significant distance before it is deposited and is outside the control of the operator between point of release and point of deposit. So that was the type of scenario in mind. And Forest and Bird helpfully provided a plan in their submissions on the same topic, which showed examples of proximity where this cross-boundary issue may arise. So that's the context of the issue. And then turning specifically to your question, we have submitted that if a material resource consent is required, and putting to one side the mooring buoys example, which may not fit into a materiality threshold, but this would be, certainly from EDS's perspective, a material issue, Section 12 consent needed, that would go to the question of crystallisation, the ability to actually exercise TTR's consents if the panel were hypothetically to grant. Obviously, they couldn't proceed to do so pending the outcome of a separate consent process, which We haven't given you the anticipated activity status, but we could do that if that was of interest. But assuming for the present purposes, it requires a consent on a discretionary basis, so it can't be relied on. There's no permitted baseline argument, for example, under Section 12. That does mean the claim benefits won't be realised for a period of time or may never be realised. And so that may be relevant to an economist assessing net benefit. That would be, the latter point would be a matter for the economist to assess and give you a view on my submission to be in that question of evidence. But as a matter of law, it would be relevant to the question of net benefit in my submission.
So just on that, and I know this wasn't your point, but we have also had some questions posed about the absence of a mining permit, and there's potentially wildlife permits. So how far does this extend? Because if we look at every subsequent type of application that may need to be sought to enable this, I think Ngāti Ruanui has identified potential cables and pipes and various other things that may also require consent. The difficulty for us is how do we actually handle that? If that creates a level of uncertainty around the benefits, then how do we actually factor that into consideration? Does that make sense? Is that clear?
It's a reasonable, it's a reasonable inference that where there are other approvals not presently sought that are still required, these may affect the net benefit. And again, it's a question I would submit you put to the economists. But bear in mind the Act, the FTAA, is meant to be a so-called one-stop shop. So if the applicant hasn't lined all the ducks in a row, hasn't applied for all the relevant approvals at the time of the application before you, then that, again, they do take some risk on that. I understand they've acknowledged that risk, although of course they would say we don't need an RMA consent, for example, other than the more important point. But anyway, to the extent that there is uncertainty, my submission, that's potentially relevant factor for an economist to evaluate when looking at net benefit. It's a relevant matter for their assessment.
Look, I'm sorry to turn our backs on you, but we want to make sure when we use this opportunity that we really do get the answers that we're looking for. And Mr. Enright, thank you for your help. I have no further question arising from your
Thank you, sir.
response.
Just for the sake of completeness,
yes.
I should point out that the joint memorandum does state that TTR denies that there would be any need for a Section 12 consent. I'm sure my friend will confirm that, but
yes.
I just wanted to be complete on that.
Thank you.
Thank you.
Yes, we understand that. Thank you. So I come back to Mr. Slyfield and Ms. Baxida. And the question sort of arising from this issue is, on the evidence, and particularly related to this question of the discharge into the CMA, is it open to the panel to determine on the evidence that the project does involve a discharge into the CMA? Would that finding be available to us on the evidence, in your view?
It's an interesting question.
And I'm happy to give you time to think about it and take some advice. I don't want anyone today to be caught out by questions that we haven't indicated we would be asking as follow-up. So if you want some time...
I think I have an answer for you, and perhaps I can circle back to this in reply at the end if I need to.
Yes.
I think the answer is no, it would not be open to the panel to make a determination of that sort, because it wouldn't be for the purpose of determining the application that is in front of the panel. That really removes from the panel's jurisdiction the task of having to identify what other consents may or may not be needed, or the factual debate that Mr. Enright properly observes exists between TTR and EDS about the nature of the discharge and whether it gives rise to another consenting requirement.
Yes. And so you would say also that it's not open to us either to inquire into whether the project involves a deposition to which Section 12 of the RMA applies.
Correct.
Yes. That's your position.
It is.
All right. Can I ask you then this question? Let's just look at this question of contingency of securing additional consents. I suppose if an additional consent is required, let's take that hypothetically, and isn't sought, and therefore the activity is not undertaken, then no benefit arises, but equally no cost or disbenefit arises. Therefore, the position is, I suppose, neutral. But can you envisage, from your knowledge of the project, whether there are any activities that might involve a specific cost or disbenefit from which no benefit might arise, such activity being one that requires a consent? I mean, I know you've said you're not required to issue consents, but is there anything in the project that might result in a disbenefit without any countervailing benefit?
Nothing comes to mind.
Right.
And I endorse the way that you've expressed it, sir, that the benefits and the costs, if I put it in my terms, go hand in hand. The only activity that could get underway that may have a consenting requirement in advance of the extraction activity would be activity related to pre-commencement monitoring.
Yes.
And as I see it, none of that activity inherently gives rise to any of the adverse effect concerns that are on the table for the panel to work your way through.
All right. All right, thank you. Don't leave the room, because my next question under 7A is for you also. And that 7A asked, are international climate conventions relevant under Section 11 of the EEZ Act, and if so, how? So are international climate conventions relevant? And at paragraph 20 of your submissions, you say that Parliament has not provided in the EEZ Act that regard must be had to specific considerations drawn from international obligations. Rather, Section 11 sends a clear signal that the Act itself is intended to implement New Zealand's obligations under the relevant instruments. Further, that intention is not replicated in the FTAA, which sends an equally clear signal that Parliament is not relying on the FTAA to implement New Zealand's obligations under those same instruments. And my question is, while that may be so, are international climate conventions relevant as aids to interpreting the statutory requirements under the FTAA?
I think on the principle enunciated in the Helu and immigration decision, the answer has to be a clear yes.
Yes.
And I think that's consistent with the findings that, Sir, you've just referred to that are drawn from that Court of Appeal decision on TTR's former application. So I think the answer there is yes, they can be aids to interpretation.
All right, thank you. Anything you wanted to ask? Thank you very much. All right. Now, Mr. Kemble has a question arising in relation to question 8.
Also of TTR. So, question 8A, for those who aren't in attendance, reads, is the effect on the climate of releasing seabed stored carbon or reducing carbon flux to the seabed a relevant consideration? And the second limb to that question is, if so, to which aspects of the assessment? Now, you've addressed in 21 the potential for such carbon to be released as a greenhouse gas. The question's not in relation to that. It's really in relation to those elements that could be considered an environmental effect, which is dealt with in your paragraph 23. So I won't read out the whole of the initial paragraph, but the question primarily arises out of your bullet point A to your paragraph 23, where you say the science in this area is still developing and subject to much uncertainty and debate. In bullet point B, it's you cite an experimental location in the Baltic Sea, which you say is not comparable, and otherwise via a theoretical global model. So just wanting a wee bit more expansion on exactly what that science looks like, and where the various experiments or models that you cite here, where they are, and how we can review them on our own account to determine relevance or otherwise.
I'm acutely conscious that the panel's been very clear this is not to be an evidential hearing. Sure. And the paragraphs to which you refer, Mr. Kemble, in some senses are referring to matters of advice that TTR has received. I can confirm that the source of that advice is Earth Sciences New Zealand, formerly NIWA, and from experts in assessments of greenhouse gas emissions. But I think I need to be a little bit careful not to go over a line in terms of giving evidence from the bar, as it were. There is certainly an opportunity, if it will assist the panel to understand what's said in the submissions, for some evidence to be potentially compiled by the suitable experts at ESNZ and provided to the panel. But this is a summary, effectively, of what that advice has been. And perhaps dealing with the first point, the point about the uncertainty of the science, and please stop me if you feel I stray into the evidential.
Well, I don't think you need to be overly concerned about that, because
yes,
we won't be taking, with respect, into account what you say the evidence is. I think Mr. Kemball's question is really saying, if we wanted to explore this further, could evidence be made available if it's not already available within the application?
It's a second question. So you say that it's based upon advice that the applicant has received. Is that advice before us?
No, it is not. No. It's an issue that has come to the fore as a result of the comments on the application and in particular, for example, the comments of the Parliamentary Commissioner for the Environment. And you'll recall that the Parliamentary Commissioner referred to some work that he had commissioned in his role from NIWA, now ESNZ, dealing with carbon emissions from seabed trawling. Effectively, the advice that TTR has received is that the degree of understanding of the science that the Parliamentary Commissioner for the Environment has developed based on that report is somewhat ahead of where the actual science sits, and it would be, in my terms, well nigh impossible for TTR to provide you with some information that you could rely on to reliably quantify in any robust fashion what the emissions component associated with the activity would be. But I hasten to add, if that is information that is of interest to the panel to receive, there would be no issue with TTR obtaining some expert evidence on that and putting it before the panel.
I suppose the matter that's before us in paragraph 22, you're saying it's an effect that we can take into consideration.
Yes.
And it's a live issue that's been raised, and then we're addressing the science of it here and saying it's developing. And we're saying, so there's two areas. There's the release of the seabed carbon, and there's also the carbon flux. Now, the applicant has addressed the carbon flux reduction in its impact assessment by saying there will be a 40% reduction. But the comment would appear to suggest that we shouldn't be relying upon, well, we should, maybe shouldn't be relying upon is too strong a statement, but that we should exercise some caution when it comes to assessing this issue, which is useful and unuseful, if that makes sense, because it's basically saying the science is developing and it's something which is in its infancy, for the want of another term.
Yep.
But it is an effect that you have to get your head around and you have to effectively draw a conclusion about. And we've gone so far as to say there will be a 40% reduction in the impact assessment. And now we're saying this statement appears to be suggesting that we should hesitate even to rely upon that statement.
Well, if I can just pick up on the part of your statement, sir, about having to get your head around it, I think that will come back to a question for the panel whether you have the best available information on this topic. And from TTR's understanding of how nascent the science in this area is, it's not possible for TTR to point to available independent scientific material and say, well, that's where you can go to find that. We're talking about an area that is at the cutting edge that would have to be the product of some additional supplementary statement that TTR commissioned and put before you. But if that is what the panel would need in order to then undertake the analysis of whether you have best available information on that, and that is absolutely part of your obligation to think through whether you have information of that standard, then TTR is very happy to get that information in front of you.
So the last follow-up question for me on that is, in terms of the 40% reduction in the flux issue that's in page 168 of the impact assessment, what was that based on?
We'll have to come back to you on that. I can come back later in the day and provide you with an answer.
Thank you.
Thank you. If you could just mark that for a response later on in the day, Mr. Slofer, that'd be helpful. All right. Now, Ms. Lovell has some issues arising under question 10.
Kia ora koutou. My question's for the applicant. So in terms of question 10, and it's the first part of the two limbs, for those not attending, question 10 says, what is the relevance of treaty principles, cultural values and kaitiakitanga to the panel's consideration, and where do they fit within the assessment framework? Now, my question of you, Mr. Seifeld, is at para 25 of your submission, you say that treaty principles should not be read into the Fast Track Act. My question is, how do you reconcile that with the Supreme Court statement in TTR at paragraph 151 and the Court of Appeal statement in Ngaronua at paragraph 46, that subject to the terms of legislation, treaty principles may still be used as an aid of interpretation, even where they are not expressly referred to? Can you help me with that?
Yes. Dealing first with the Supreme Court's reference, in my submission, we have to remember that the Supreme Court was operating under the EEZ legislation, and the provision in the EEZ legislation is expressed in different terms than the relevant provision, Section 7, in the Fast Track legislation. So there is a difference in terms of legislative expression there, one referring to principles and the other referring to obligations under treaty settlements, which in my submission is a meaningful distinction, and that is where a line needs to be drawn in terms of reading in principles which have been not explicitly carried over into the Fast Track legislation in the way that they are in the EEZ legislation.
I think I have difficulty with that, particularly when I do look at 151, because the court is not limiting its observations to the EEZ Act. I mean, the court is actually quite clear. The court will not easily read statutory language as excluding consideration of treaty principles if a statute is silent on the question, not just the EEZ Act.
In my submission, whether the Supreme Court says in a given passage that it is applying the EEZ legislation or not, that is, as a matter of law, what it was doing. And so it did not need to say that it was applying the EEZ Act in that particular passage in order for that to be the case.
And you consider that would limit us in terms of our
yes.
assessment? Okay. Moving on to the second limb, so this is around existing interests. And again, noting at paragraphs 26 and 27 of your submission. And in that, you address the concept of existing interests. Again, do you accept that in light of the Supreme Court's decision, tikanga-based interests fall within existing interests? Or do you say a different approach applies where the application is made under the Fast Track Act? And this follows, in some ways, to the answer you've just made. I can repeat the question if it helps.
No, I think I understand it, but if I don't answer the question, then by all means repeat it. But no, I think the answer is yes. That is where tikanga-related interests fit in terms of the framework that you're operating under, which is both FTA and EEZ legislation. And I've been thinking about the question that you've posed about 10B and this relationship between existing interests and obligations under treaty settlements. And I think part of the answer to that, and it is only part, is that the existing interests are defined in the EEZ Act in a way that, on the face of the definition, refers to interests in a settlement. And bearing that in mind, it may be the case, depending on the circumstances and the evidence before you, that looking at an effect on an existing interest, which is an existing interest arising out of a settlement matter, and looking at an obligation under the relevant settlement, are really just two different sides of the same coin. So it may be that in terms of the way the question was put about what's the distinction legally between the test that must be applied, depending on the circumstances factually, there may not be a meaningful distinction to be drawn. Now that I submit won't be the position in every case, because there will be some situations where there might well be an existing interest, but there is not a corresponding obligation under a treaty settlement. But in other situations, it may simply be different lenses of looking at the same subject matter, one from the perspective of the holder of the interest and the other from the perspective of the Crown as the holder of the obligation.
Kia ora, Mr. Slyfield. For me to move on, or shall I wait for...
All right, the next issue is that Mr. Kemble has a question arising under question 15.
Correct. It's for Council for South Taranaki District Council. Again, for those who aren't in the room, question 15A reads, to what extent, if any, is the potential for offshore wind energy generation in or near the project area relevant, whether as an existing interest under section 59.2B or B, the second limb, under section 959.2G of the EEZ Act, or otherwise. Question. And the second limb is, if the potential for offshore wind energy generation is relevant, how should it be taken into account? So, in the legal submissions for South Taranaki, paragraph 4.5 in particular, it basically says that even if we do not conclude that the wind generation projects are an existing interest, that we could consider them under 59.2G, and we have to inquire as to whether it's an efficient use and development of the natural resources. So that's the context. So my question is quite simply, the question is just to start in baby steps first. So fundamentally, I understand the submissions to be that we need to consider what is the most efficient use of the site. Is that a fair question? A fair summation of the advice before us, or that we can assess what is the most efficient use of the site?
I would probably state it slightly more focused on the provision which talks about whether the activity is an efficient use of the relevant of use and development of natural resources rather than whether it's the most efficient use and development. And so to that end there is a limit here, perhaps with reference to section 7 of the RMA, where I don't think that provision in itself requires a comparative assessment of relative efficiency between a current proposal and some other proposal that's not before the decision maker.
So if I understand you, we're basically following the same thought process of that the High Court landed on the Meridian's Project Hayes wind farm, that it doesn't require that comparative assessment, it doesn't provide a full cost benefit assessment of what is the efficient use. We literally stand back and look to determine what is before us as being whether it's sufficient or not. Is that?
Yes, by analogy to that RMA situation in that Meridian case, that is the closest I think we've got to a steer on what this provision would look like in practice.
Okay, thank you. That's all I know.
Thank you. And Ms. Lovell, question 21.
Kia ora koutou. This is for Council for Te Ohu Kaimona. Won't be surprised. In relation to question 21, and again I'll repeat it, in relation to section 85(1)(b) of the Fast Track Act and the obligations under section 7(2) of the Fast Track Act, again, to act in a manner consistent with the obligations arising under existing treaty settlements and customary rights. And I'll jump to B. If adverse effects on fish stocks or aquaculture stocks are found to exist, would granting the application be inconsistent with obligations under the Fisheries Act or Fisheries Settlement or the Māori Commercial Aquaculture Claims Settlement Act? My question is, in your submissions, you say the Crown must uphold the integrity and permanence of Māori Fisheries Settlement. So the question is, does that include maintaining the fishery or resource itself?
Sorry, Ms. Lovell, I'm pausing because my mic doesn't seem to be working, but perhaps I'll just... Oh, now it is. Thank you. Never did that. Tēnā koutou. I think the short answer is yes, to the extent that, I mean, just taking a step back, and I want to make sure that I'm answering your question, but the way in which we've approached our submissions on this question is to contextualise the integrity of the settlement itself. And of course, if there are, what we say is, if there are negative effects on the fish stock, then of course the panel can take that into account in the context of upholding the integrity of the settlement. But what we've also tried to emphasise is it's not simply about the fish. And so, again, I want to be clear that I'm answering your question, so please just let me know if I'm not. But that does impose an obligation on the Crown to ensure that when it is developing different legislative frameworks that were not in the mind of people at the time of the Māori fisheries settlement, it does so with a mind to ensure that the settlement can be upheld. And what we also say in this, in our submissions, is that it has done so in this Act. It has said that if the panel is of the view that there are inconsistencies with the Māori fisheries settlement, the panel must decline. And so, again, let me know if I haven't answered your question squarely, but that does provide an obligation on the Crown to ensure that when it's developing these legislative frameworks that it has a mind to upholding the settlement.
I guess the question is there's the Crown's setting up frameworks, and then there's the question of maintaining the fishery or resource. Are they one and the same?
I don't think they're one and the same. I think that when the Crown is, let's just say, putting in place this new regime, it has to have a mind to the fishery settlement, which means that it has to have in mind to what the effects are going to be on quota, for instance, or customary fishing rights. And we would say it has done so in this case, and it provides the panel with a clear directive that if the panel is of the view there are inconsistencies, then it must decline. So I don't think it's the same, but I think that they are interrelated.
Okay. And just following that line of thought, what is it about the effects of this application that, in your view, makes it inconsistent with the settlement when other changes that affect the fishery would not?
Other changes that it would affect this fishery, like climate change, for instance, or, sorry, I'm just trying to think about.
I haven't got it right in front of me in terms of your submission, but I think the question is, in your submission, you note that in some instances, effects haven't gotten to the point of inconsistency.
Yes.
And with other matters, but my question is, what is that distinction? You know, we have it here, or do we? What have you seen in terms of other instances where that threshold has not been hit?
Met. Right. Yes, no, I understand the question now, thank you. And I think it is at, and it may be where, I was just looking at it. Is it the point that not every effect is going to lead to an inconsistency? Right, yes. And so how I would think about that, and again, just let me know if you, is that what we've done is focused on the effects of TTR's application. So there may be instances where there are effects that don't necessarily lead to inconsistencies. We haven't, I think that the point of making that submission was we just simply don't know, but it's not to say that things aren't going to affect fish stock. I mean, we know that things affect fisheries, but why I think Justice Bolt's decision is really helpful is because in that case, His Honour effectively said, well, that's the Crown in the context of the Section 28N rights affecting the quota, and therefore that's a breach of the fishery settlement and the Crown needs to rectify that. Here, I think the Crown's given the panel direction to say, well, if there are inconsistencies, and we say that there are, that are focused on, I mean, we've addressed where we say they are in terms of the fish stock, that is a ground to decline. Now, I haven't sort of thought about every instance where the panel might think, well, that doesn't lead to a circumstance of decline from an inconsistency perspective, but I think that not everything in the sea may lead to a decline, may lead to an inconsistency with the Māori Fisheries Act, but this is a huge application, and so we say that it does. There may be other things like wharves, or I'm not sure, but things that are far more straightforward than what the panel has to consider before it, that don't lead to an inconsistency.
Okay, thank you.
Right, thank you. And finally, I have a question directed to Council for TTR under question 21A, which reads, in relation to section 85(1)B FTAA, and the obligation under section 7.2 FTAA to act in a manner consistent with the obligations arising under existing treaty settlements and customary rights, are the members of the panel exercising a judicial power or performing a judicial function or duty in terms of section 7.2 of the Act. Section 7.1 says all persons performing and exercising functions, powers and duties under this Act must act in a manner that is consistent with the obligations arising under existing treaty settlements and customary rights recognised under the Marine and Coastal Area Takutai Moana Act, the Ngā Rohe Moana o Ngā Hapu or Ngāti Porou Act, and to avoid doubt, subsection 2 says, subsection 1 does not apply to a court or a person exercising a judicial power or performing a judicial function or duty. And in TTR's application, submissions on question 21, it is said, the members of the panel are exercising a judicial power or performing a judicial function or duty. The nature of the panel's role to impartially determine the application, including by evaluating and deciding matters of contested fact, supports this interpretation. So my question is, does that mean that the obligation under section 7.1 applies to everyone performing and exercising functions, powers and duties under the Act except the panel?
I don't think it's as simple as that. I'm sorry. I think there is an ambiguity in the legislation because I think that the conclusion that you've expressed, sir, is one that you're inexorably led to if you look exclusively at section 7. But of course, we know that section 85.1 indicates quite a different intention, and I think in terms of assisting the panel to join the dots on that, so to speak, I can't go further really than to say that you could not be giving effect to 85.1 if you were to apply 7.2 according to its face. There is a need to reconcile this apparent tension between those two provisions in my submission. One way that can be done is the way that it was done in the Bledisloe Wharf fast track decision, where that panel gave a decision whether it was or wasn't exercising a judicial power in both directions. And I dare say that may be the only way that decision could be made so as to be immune from an appeal on a point of law.
But the tension you describe arises only if you are right that the panel is exercising a judicial power.
Yes.
And it's interesting that subsection 2 is prefaced to avoid doubt, so Parliament was trying to make its intention clear, was it not?
It was intending to.
Yes. So wouldn't it have been easier for Parliament if it wanted the result you argue for, that it could have said simply in section 7.2, the obligation under section 7.1 does not apply to the panel? Wouldn't that have been a much clearer way of expressing the view that you have as to what subsection 2 was on about?
Yes, it would.
Yes. Or it could have said in subsection 1, I suppose, all persons other than the members of a panel appointed under the Act. Does that strike you, if that is Parliament's intention, does that strike you as odd that it should place such prominence in the Act in section 7 on compliance with obligations under treaty settlements, and yet the body which is charged with the responsibility for making the decision is not bound by that obligation? Does that not strike you as strange?
Very strange.
Yes. So you accept that your proposition is one that Parliament, if we look at it carefully, may not have in fact intended?
Yes. That's exactly the view I've come to about the tension that arises if you adopt my interpretation of 7.2. Yes.
Thank you. I appreciate that. All right. Well, that is the end of the list of specific questions we have. So we were right to let you know that we didn't think it would take very long, but that's partly because your answers this morning have been very helpful to us and we're grateful to you. So I now want to ask you, and you may want to take some time to think about this before you do the answer, how we make best use of the remaining time available, and to give you an opportunity to make further submissions to us, either on matters which have arisen this morning, on which you haven't commented, or matters which arose from the submissions of other parties on which you haven't, which you may feel you haven't adequately addressed yourselves, and also to give the applicant an opportunity to respond to some of the answers that have been given by commentator parties this morning. And my question is, how long do you think you will need to decide what questions you want to ask? Would an hour be sufficient? Would you like a little bit longer than that to confer with each other and work out a way in which you will approach this? We're in your hands. We want to make the time available to you and to use it in the way you think might be the most useful. So if you'd like to just talk amongst yourself briefly, would an hour be sufficient? We'll give you more time if you think an hour would be longer for you to prepare, and then we can make whatever time you think we'll need after that to hear from you.
So you're suggesting an hour's break?
And yes, so that you can prepare the submissions that you want to give us. If you want longer than that, just say so. We'll give you that time because we've got plenty of other things to do while we're waiting.
I'm getting self-appointed shop steward here. I'm getting shaking head, so I canvassed the room and said, is everyone ready to make submissions now? Would we like to take an early morning tea break or just box on?
Some of you may want some time just to prepare your thoughts on this, so, but would an hour be too long or not enough? You let me know.
So I think the consensus
An
is
hour?
an hour would be too long. If we could take an early morning tea break, take half an hour now.
Yes.
That would then allow us to come back while Mr. Enright's still got some time available.
Yes.
So we might arrange ourselves so he could address you first.
All right. Let's reconvene at 10:50, so 10 to 11, and we'll hear from you. And then we will take other breaks. We'll take lunch break and so on as we go through. All right. Thank you very much.
Thank you.
Push in. Why are they being so timid? They need to be more. Yeah, I just know that will be a search. Yeah, I know. How are you, sir?
Hey, Grant.
Here we go again.
Yeah, here we are.
Oh, sorry. I know it's so hot in here. But yeah. Sorry, I didn't mean to give you. Yeah, why did you talk? I know that's all.
Yeah.
That's why I started
Could we take a step back? Can you tell me what does
Well, I was only gonna, I was just gonna address one consensus point just to raise the Ngāti Porou case, because I yeah. Because you
It's not that it will drop by 40%.
Goes from 1.7 to
1.9. 1.9 to 2.9.
Yeah, I've just said that. So this was discussed extensively in the expert conference on Monday. And so I've just said that going through to it's still not the official issue.
Yeah. So it's changed from 1.9 to 2.9, which is a 40% change. That's the clear point. It's not a 40% reduction in flux. It's a change between the two assessments. 2.9. Yeah.
2.2.
1.9% reduction over the whole of the modelling domain to a 2.9% reduction over the whole of the modelling domain, which is a 40% increase.
2.9 is 40% more than 1.9.
Yeah.
At the risk of oversimplifying, stating the obvious.
So this...
Simplify maths, but I'm concerned.
You got the point?
Yeah.
It's still a 3% change. To under 3% change.
Under a 3% reduction, but a 40%
change from what the original modelling
from the original flow modelling to the worst case. And somehow, and so that was a point of clarification that the experts developed and documented in the expert conference in Ontario pre-production on Monday. And I don't think people have seen it yet.
I'm interested in what your impressions are of the lack of question.
It's not a our system. I mean, she hates us. Seems to me kids are running out. That's right. That's right. For a bully, we don't feel it's going to be okay. So we don't have some conditions.
And we've said no, we've got to do that. But that's not an argument. That's not driver's license.
Well, you might get a feels to the side. If you want, you can't do it. If you turn it off, you don't know. We don't know.
But that makes sense.
They say, well,
which is, I mean, interesting. We get some people in our submissions. So I take someone that I had a rookie card, we don't so the program is you just, you can't do that. We're spending enough money to put it there rather than front out there. My shareholders should just go to the circuit. What are you doing that? I think they realise that the question is a very good question because they have the statement in their submission. We're not saying anything but TTS, and they don't particularly want to read about I think they would provide an Australia. Yes. I think they have enough interest for it. We have an argument response. You have to start it's ground up. So you look at it, are we inherent on a response that's more negligible and our evidence is inherent. So even if absolutely. Because all this is guys, just more that's what it should be. Always chance. I think the difficulty that's up and what is the obligation? That's very clear. The obligation is the fish stock never goes up. And I think what probably goes back to is that they're forced to have sort of pull back and say, go back and see it's an obligation not things that weren't in the minds of the settlement parties at the time of the settlement, a la table time Bolt's decision, things of that nature, to come along later and basically take with the other hand what you gave with this hand.
It's a very dangerous thing.
I think we would say that decision is a very clear decision in the sense that it was here's quoted 10%. And now we are literally reappropriating some percent of that quota from you, rather than we're having an effect on fish stock. Yeah, I have to, because it's one of the few things where it's gone up in the air, and I don't think we're really gone. I'm not sure it's actually, and I'm surprised. I actually was being pretty neutral. I mean, the only bit that I found was forgetting that she has a holder of a law degree. She knows full well how to read accounts in its context. And say that. What were they applying then? Yeah. I think yeah, please.
So, the report I sent you,
yes,
which is draft, is expert confidence and
yep.
I see so fluxes the
what parallel are we at?
In 40 and 41, paragraphs 40 and 41.
Right.
Because this question from the panel is about flux, and flux is when there are two parts to the flux question. The first part is what is produced in the water column.
Yep.
Or by primary plant production, we work a lot on seaweed. And then how much of that is then fluxes what is taken up by the big organisms.
Right.
And so you'll see in the 41 is really about the production side of things. So you see that the 3% relates to the reduction in primary production between the original number and the best effects.
Right.
And then the energy flow to the seabed, which is in B, follow B, which is the flux. The energy flow to flux to the seabed, you see was the absolute values of current here coming into originally 5.8% reduction, and this cost me So there are two parts to that story. Is the reduction in primary production by a small amount, provides a 4% increase from the one small amount to the second small amount. And then the flux, the uptake of that to the seabed through filter feeding and that sort of thing.
This is still draft, hasn't it?
Well, we've all signed it. It's probably wending its way towards it. It's working on that. We signed it off yesterday.
Yeah. Yeah, that 40 relates to this.
It's been clear. All this has been clarified. The joint won't foresee.
Yeah.
But give 40% out
yeah.
It's a 40% change.
Yeah.
It's not in their interest.
Well, that's what I was thinking. Oddly, because we get set aside the whole day, they're now saying, just take it up. Tell us what you want. I mean, it's... And so I guess the only thing from my mind is we have to hang around.
We just reply.
And wait and see what we're not going to offer anything.
No, I agree.
It's only, okay, what outrageous things do they say that we decide?
Why don't we make the same on China? There's nothing that's was about.
Well, I don't think they came along. They were going to have to present because that was how they said this was going to work. I don't think they're going to miss an opportunity to present some stuff, but I'm not sure that they're. I mean, some of the answers that probably a few of them have been asked questions. So, well, come on, I didn't think those answers were at all very seat in your pants.
See, hey, why don't we go get coffee? You don't have to.
There's no such thing as too much. I like thinking turning to standing outside. Because I'm like, okay, she's going to tell them which way is up.
I'm going to leave my Thank you.
Thank you. Alan, do you want us to bring you a coffee?
No, I'm fine. I've had a couple of swings. That's about.
Okay, we don't want you going up to the ceiling.
Exactly. Go for a bit of a walk.
It's easy for someone to still fast.
Let's walk around. Oh, yeah.
No, but I wasn't really thinking, I should tell you how come they want it.
Yeah, that's good. I don't know if maybe I'm so used to abandoning the past. People like
Me and my sister friend a lot there, a lot. Thinking about you going away, you always bring back and say they can park up. That's really clean, and you just tell them, when you go to get your bags, just call us and get your bag when you're wearing 5 minutes away.
disproportionate to actually based on where that bubble is. I found something.
We're going to plan, is it?
So,
Yeah.
it's a little bit. Yeah, you guys all good?
It is, no surprises, so.
We're just glad you're being actually fit through.
Yeah, sure, it's a bit of a squeeze. You've done well because we did get past thousands to get in here. That's a bit tricky.
Yeah.
A little bit surprised at process.
Yeah, they were.
So it's got heavy head and all, I'm not sure. Hey, I believe that.
Do you think that, I mean, I think that one of the positive events is kind of made. I think it's just really low.
Yeah, it is. Legislation applies. There is a lot.
Thank you. When did you arrive? This morning? Oh yeah, well you can't help it. Oh, really good then. Fair enough. Oh, I didn't. Oh, you know, that flight actually really soon. No, I was safely at the airport. Oh, okay. I saw that on the news. I know, it was quite exciting, wasn't it? I was like, oh shoot. I was very happy because I've been planning to maybe take all my luggage. Yes.
Sorry. No, you're right.
Yep.
I've done that.
Yeah, that's mine.
You got your other one.
What's weather like this time of year? They were complaining. I know. It should be flying time.
Four of them sitting up there.
But then it's quite probably like freezing.
Like June, July.
Te hei mauri ora. Well, I'm going to ask Ms. Lovell to remind you of her question 10 follow-up issue, the second part, and that that question will be directed first to EDS, so that Mr. Enfield can deal with it, and then we can hear from you on any other matters that you might have that you want to raise with us before 11:30, and then we'll come round to the room. We have no particular method, just put your hand up and say you want to speak about something and we'll hear you. Right.
Kia ora koutou. I'm going to say that question one more time. So the question is, and I'll say it as a whole, so it's 1 and 2 limbs. You can choose which limb you want to pick of the body, arm, leg. What is the relevance of treaty principles, cultural values and kaitiakitanga to the panel's consideration, and where do they fit within the assessment framework? And then the second limb is, in particular, what is the correct legal test to distinguish an effect on an existing interest as defined and used in the EZ Act from an effect on an obligation arising under a treaty settlement under the Fast Track Act, Section 7(1)(a). Now, I'm about to ask Mr. Enright if he has a response he would like to provide, and then after that, it would be helpful if we can confirm any other party who wishes to speak on this matter, and to help with the record, if you could just confirm your name when you speak. So, kia ora, Mr. Enright, did you have any submission to make on that question? You're on mute.
I'm sorry, was there another question? Can you hear me? Okay, great, thank you. Just wanted to make sure. I do have one other topic to address, but I'm happy to wait.
Okay, sorry,
if you
so...
prefer.
Okay. Yeah, absolutely.
So, Mr. Enright, why don't you address the issues you want to address? We know that you're under a time constraint, so you just tell us and then we'll return to Ms. Lovell's question later. Thank you.
Thank you. I'm grateful for the indulgence. The only topic I'd like to address, obviously otherwise rely on the written submissions, was question 24, and this relates to the Section 85 test and the reference to policy instruments and statutory provisions in Section 85 bracket 4. So it's the solely issue. How do you manage policy instruments? Can they tip the balance? And I just really wanted to respond to a point made by TTR in their written submissions at paragraph 75, where they say that there's essentially a statutory bar on a policy instrument tipping the balance as a result of the language used in 85 bracket 4. So I just wanted to clarify, EDS takes the exact opposite position on that, that a inconsistency with a policy instrument can indeed tip the balance. If it was in very simplistic terms, a question of, the only provision the panel found that the proposal was inconsistent with was a policy instrument such as a policy in the NZCPS, then that would obviously couldn't operate solely to justify decline. But where there are a number of factors, which invariably there will be, again, picking on the NZCPS as an example, where if you generally the policies are effects based, so you would have an evidential basis as well as a policy basis. But you are not precluded by the language used in Section 85.4 from declining in reliance on inconsistency with a policy in addition to other factors. So I just wanted to draw to your attention that is a sort of a fundamental point of disagreement. And just related point is that you may recall we addressed you in Hawera around the question of environmental bottom lines, and that they still have an ability to operate in our submission under sections 81, 85 of the Act. And again, although we recognise that inconsistency with a policy provision cannot be of itself determinative, but may operate again in tandem with other considerations in terms of the proportionality test. And of course, environmental bottom lines often relate to biophysical matters and are very strongly founded in evidence rather than just a matter of what a policy provision might for itself say. So those were the main points EDS wanted to emphasise to you, and also to express my gratitude that I was able to appear online. Mr. Commissaris will be there if any other matters arise for the rest of the day.
Well, that's very helpful, Mr. Enright. Thank you very much, and thank you for taking the trouble to join us in this way. Thank you very much.
Kia ora koutou, and the floor is yours.
Now remember, the approach that Council discussed over the break was that if it suits you, that we might just essentially go front of the room to the back,
yes,
address highlights from our submissions, things we'd like to respond to from the discussion this morning. Those who were addressing question 10 anyway have noted the question. I think on my list that would be myself, Ms Walker, Ms Rongo and Mr Ferguson, perhaps Mr Conway for the Taranaki Regional Council. So we're prepared to just take those on the way through. If we don't, you'll pull us up, I fully expect. So if you're happy for us to just go, I think...
Yes, we're very happy for you to approach.
I think that would be less disruptive than trying to go question by question. And
I think, Ms Innes, if you and everybody else, when you're speaking, please just identify yourselves and the organisation you're representing, so that will help us with the transcript.
Thank you. Thank you. So first of all, Ms Innes for Te Runango Ngāti Ruanui. Just a couple of points on the early questions, things that were discussed this morning or not. Question 1, which relates to the factual findings of the 2017 DMC. Nothing to add to the written submissions, but I would just point to the submissions for Tallies and Seafood New Zealand, who aren't represented here, usefully also pointed to the efficiency principle, if I could put it that way, in the statute, supporting the idea that you could certainly look to those previous findings, as well as the requirement that an applicant who had a previous application provide that information. Clearly, that information was supposed to be before you. Seems efficient that you might look at it. We also made the point that panel wasn't time constrained in the way that you are, and had hearings and full testing. And I should just say, so when we compared notes, assessment of council was that we might each take somewhere between 4 and 20 minutes. I'm not at the 4 end, but hopefully not the 20 either. So that was comments on question 1. Question 2A that there was some discussion about this morning. Just 2 points, if I can. We perhaps a little overly boldly stated in submissions that we think that the panel should determine whether RMA consents are required. I just modify that slightly. I agree with my friend Mr Enright that that's not a jurisdictional question. It's not that you must require this applicant to apply for consents they don't wish to. It's not going so far as to saying you cannot grant the consents they seek if you're of the view they also need RMA consents. But I would align myself with his submissions that if there is at least a reasonable prospect that further consents are required, whether it be under the Resource Management Act or otherwise, that must be relevant to your consideration as to whether grant of these consents would achieve the purpose of the Act. So I see it a little like the feasibility question, which I don't think I'm going to address now, but it's should you be discounting the potential benefits of the project, if any, for the risk that it either may be delayed or may not materialise because of those other processes which are outside your control. So just to reconcile those two positions. One other point, and perhaps I misheard, I thought the Chair asked Mr Slyfield the question as to whether the panel could conclude on the evidence that there would be discharges in the coastal marine area. So to me, clearly the answer to that must be yes. The sediment modelling shows that this discharge visits itself in the coastal marine area. Not unreasonably, Mr Slyfield went to the next question as, should you then conclude that therefore RMA consent's required? That's a separate question which I've just spoken about. But I think on the factual question, clearly the evidence is that discharges will occur in the coastal marine environment. And from some of the expert caucusing last week, there's also the question of mounds, pits and mounds as it were, which will migrate downstream. So clearly these effects are felt in the CMA.
Can I just so that I understand this, it seemed to me that it's arguable both that where the discharge is taking place within the permitted area, so within the EEZ, and not in the coastal marine area, it's arguable that that's all that would be sufficient for TTR to say we are discharging outside the coastal marine area. Your argument, as I understand it, the argument of others, is that the discharge might take place there initially, but because the sediment then moves into the coastal marine area, then the legislative provision applies. Is that really the contest?
That's right, and at paragraph 11 we talked about section 15B of the RMA, which refers to discharges of a harmful substance or contaminant from a ship or offshore installation. Now in this case, the discharge is, to all intents and purposes, in the CMA. That's where it will have its main effects. The source of the discharge is not, and that's the confusion here.
Thank you.
Nothing to say on question 3. Question 4. Sorry, just one point on question 4. TTR says that feasibility is not a relevant consideration because this is conceptually the same as any other consenting process, where the risk that the thing I want to, the moon landing plant that I want to build may not be feasible, that risk's on me as applicant. And with respect, I don't think that this is exactly conceptually the same as other consenting processes, because the purpose of the Act is to facilitate projects that have particular benefits. And an infeasible project obviously cannot have benefits. Point made, it also can't have disbenefits, but that's not the test for that's not the way that the purpose is framed. To facilitate projects that will have, I would say, net benefits. So feasibility must be relevant to that, and I don't think that the aligning of this framework with more normal consenting frameworks we're used to is entirely on point there. Turning pages, in terms of question 5 and the categories of benefits, I get a little nervous here because it occurs to me that economists use terms a little differently from us lay people, so I was a little nervous on that, but I would just point to, we've sought leave for such for Dr. Nana's response to the joint witness statement on economics to be received, and he makes the point in that response, as he does in his initial evidence, of the value of a total economic value approach, which does its best to bring in all of those intangibles and imponderables. So it is ideally in the broader sense of that that goes beyond even the cost-benefit analysis. As I said, though, in the submissions, that's because that is not the analysis that's before you. The obvious argument of double counting doesn't arise, so you need to deal with the evidence that's in front of you. Again, Dr. Nana makes the point that, in his view, there is some double counting of benefits in the analysis that is before you. So we just take the opportunity to say that.
I don't know whether it may not have reached you yet, but we've decided to accept that information.
Thank you.
Formalities may not yet have been completed.
Very good, thank you.
We'll take that into account.
I will skip over questions 6, 7 to 9, which gets us to question 10. Before I go to the second limb of that question, which, as you say, entirely our error that was omitted from the table of questions, clearly also our error that there was a bit once over lightly in the written sub, so let me take that. Before I do, just a response to the conversation this morning about the relevance of the principles of te tiriti, I'd just make the observation that the jurisprudence on the principles as they relate to statutory interpretation doesn't just sit on the TTR, on the Supreme Court decision in TTR, whether that was confined to its statutory framework or not. That's a decision that was based in actually quite a long line of jurisprudence now. And our footnotes to paragraph 30 refer to decisions back to the 80s, to Huakina Development, Barton Prescott, and so on. So that's, I would say that this is actually just an orthodox position that really doesn't need to lean too heavily on what might just be the most recent decision. So, the question of existing interests and treaty settlement obligations and how they interrelate and overlap and should be treated within the statutory framework. The first point, quite obviously, is that the interests, for want of a more elegant term, of iwi and hapu, of Māori in this space, they're based in whakapapa, they derive from their mana. They are holistic. I think Justice Churchman, in a Takutai Moana decision that I appeared on, which is now no longer a decision, unfortunately, referred to the people of Ruapuki, for argument's sake, as having an integrated and holistic relationship with their seascape, which is a phrase that appeals to me, albeit that it's not as elegant as my friend would deliver it in Te Reo. So these relationships, they're not easily amenable to being sliced and diced, notwithstanding that statutory frameworks require us to do that. But clearly an existing interest, as that term's used in the EEZ Act, is the broader concept than an obligation under a treaty settlement as used in this statute. So essentially, though, what I would say is that one is the superset, the existing interest is the superset, treaty obligations are a subset of that. The kaitiaki of iwi and their rohi is an existing interest. The Supreme Court recognised that, and so that's a matter to be considered via Schedule 6 consideration to Section 59 of the EEZ Act. But that kaitiakitanga will also naturally be reflected in the treaty settlement obligations. It's only logical that there's that overlap between what I might call the substantive interests and the things that are expressed in treaty settlements, because those are the rights and interests that iwi go into treaty settlements to seek protection and recognition of. The practical distinction, and I will come to the legal, but the practical distinction is that treaty settlements are fundamentally about the relationship between iwi and the Crown, and the mechanisms that those, which translate as settlement obligations, the mechanisms that settlements, for all their imperfections, deliver are mechanisms for that relationship to be expressed with the Crown, or as I would say, with its agents and local authorities. Mr Conway might just disagree with that characterisation, but they are mechanisms for that relationship to be expressed. The substantive interests, those tikanga-based interests, are about the relationship between the people and the taiao and the things that live within it. That's fundamentally, if someone crudely in my terms, that's a whakapapa relationship. So I will pause and you will want to ask me a question, I'm sure. So the Ngāti Rōnui position is that granting this application would be consistent with its treaty settlement obligations, because those obligations include mechanisms that tie into decision-making through the RMA, decision-making through the Fisheries Act, decision-making through the Conservation Act, and other mechanisms. This would be a decision that fundamentally impacts on their interests that is made outside those frameworks, so that they don't have those rights of participation that their settlement guaranteed them, and that those mechanisms, the settlement guaranteed them through various mechanisms, and that those mechanisms again are underpinned by Crown apology, which elevates the status of a relationship between the treaty partners. So that is their position, that this would be inconsistent with those mechanisms because it would bypass them, and by bypassing them it would create changes in that marine environment which would then devalue those instruments going forward, because all decisions taken going forward would be effectively under the shadow, or the plume if you like, of this activity. So coming then to the legal distinction in terms of framework, we would say that all existing interests of the iwi and hapu, including those treaty settlement interests, must be considered as part of the Schedule 10 assessment. Sorry, I think I said Schedule 6 before. The Schedule 10 assessment through that Section 59 of the EEZ Act. And adverse effects on all of those interests must also be considered in Section 85.3. So, the conclusion is that if you agree with us that granting this application would be inconsistent with the treaty settlement obligations, then clearly you would decline it under Section 85.1. Even if you take the view that it doesn't rise to the threshold of being inconsistent with those settlement obligations, you can still take the view that it would have very severe adverse impacts on those treaty settlement obligations as part of the full bundle of iwi hapu interests, and that those adverse impacts would weigh against benefits in the Section 85.3 assessment. Did I get there? I'm not saying that you agree with me, but it's in terms of addressing the question on its terms.
We understand the submission.
Thank you.
Very clearly expressed, thank you.
I don't think I need to add anything to question 11 in terms of the Justice Bolt's decision. A friend addressed that. I won't talk about iwi management plans. I'm going to flip forward to question 14A in terms of habitats of particular significance to fisheries management. It's not one that you had questions on. Again, I would just point to the submissions from Seafood New Zealand and Tallies, especially at paragraph 18, where they go into this in some detail, and they make reference to Unison Networks case about the fact that whether, by analogy, whether such habitats exist is a factual matter. It's not a matter of being able to point to a thing on a plan. It's a consideration because the habitats are shown to exist on the facts. So that was very briefly on that. I think the last 2 points I'd like to address. Question 21A in terms of section 7.2 and this next question of whether the panel is exercising a judicial function, which it has to be acknowledged it very much does feel like today. The judiciary is always kind, sir. Look, I do take a different view from my friend Mr. Slyfield. I think reading section 2A is applying to the panel and then saying, but clearly it doesn't for section 85.1, just seems unsatisfactory to me. and I think a better answer is required. We said in the submissions that, that the better reading is that section 7.2 should be confined to the courts. We referred to a submission the Chief Justice gave on the now repealed Natural and Built Environments Act. We actually did a little more work. It's been an evolving feast. The Chief Justice actually gave that same submission on this bill, saying that it wouldn't be, I'm happy, I found it on the parliamentary website, happy to send it through, but raising queries as to the application of a Section 7 type provision to the judiciary. She raised 2 points, that and that the regulation making power could impliedly allow regulations to be made which would impact on the administration of the courts.
Could you, just thank you for that reference. We could probably find it would be easier if we could just send it into the EPA.
I'm very happy to do that. It wasn't easy to find because there were some tens of thousands of submissions, of course.
Well, if you just send it to Keely,
will do.
Thank you very much.
And I don't think it's a long bow to draw to say that is what motivated clause section 7 subsection 2. The Select Committee report says we recommend replacing clause 7.1d with clause, no, that's not the right one. One moment. We recommend inserting clause 6.2 as it was then to make clear that clause 6.1 does not apply to the courts or to any procedural or administrative matters of the courts. They made a similar addition to the regulation making power to make it clear that regulations could not be made that would impact on the administration of the courts. So, notwithstanding that the phrase that was used was exercising a judicial power, the best evidence we've had, and there is nothing in Hansard we checked, the best evidence we have of Parliament's intent is that they thought they were excluding the courts and the courts only.
And you'd say that in conventional terms we can look at parliamentary proceedings such as the Select Committee's report to aid our interpretation of the statute.
I do, sir. I totally agree with Mr. Slyfield. There's a clear ambiguity or inconsistency there because you really can't read clause 7, section 7.2 and 85.1 together unless one of them bends to the other, if I could put it that way. I think that parliamentary material is a useful guide that says, well, we don't need one to bend to the other. If we simply recognise that Parliament was talking about the courts, then that logic flows through appropriately to 85.1. So, last point I would like to make just picks up on a kōrero with my friend Ms Erwin Easthope about the fisheries settlement. And two things I'd say on that is, the one, in terms of the question, and I hope that I reflect it properly, is does the Crown have a settlement obligation to maintain the fisheries resource, essentially? That goes a little bit outside the submissions that were made here. I would say that it does, in fact, it does have an obligation to maintain the resource, and that obligation comes because first of all, in the Fisheries Act, the fisheries settlement is intrinsically bound with the quota management regime and the fisheries management regime that it sits within. We needed quota to deliver for the settlement. The two cannot be unpicked, essentially. The Fisheries Act, the current Fisheries Act 1996, recognises that, says that the Act's to be interpreted and all persons exercising powers and functions, so and so, in a manner consistent with the provisions of the Treaty of Waitangi Fisheries Claims Settlement Act. Fisheries Act to be interpreted consistent with the Settlement Act. Section 9 of the Fisheries Act is its purpose. My apologies, Section 8. Its purpose is to provide for the utilisation of fisheries resources while ensuring sustainability. So the driver of the fisheries management regime is to provide for utilisation while ensuring sustainability. If the Crown was acting in a way that was not ensuring the sustainability of fisheries, it would not be achieving the purpose of the Act. I would say it would also be in breach of the fisheries settlement because of the manner in which those things are so inextricably linked. So that was my answer to that one. In terms of the question of are there examples of impacts on fisheries which would not rise to the level of inconsistency with settlement obligations, perhaps a little tangentially, but we provided a couple in the written submissions. The one at paragraph 67, where we make the point that, as I say, through our fisheries management regime, annual decisions can be taken on total catch allowances. The decision-making machinery for that is provided in the Act. There's rights of participation. When a catch allowance is reduced, the value of settlement quota is reduced. But that is an impact on that settlement obligation, which is not inconsistent with the settlement because it's bound into the settlement. It's contemplated by the machinery of the settlement. That's the nature of quota. So that's one example of where an adverse impact on a fishery wouldn't be inconsistent with the settlement. The other that I gave there, which is we'll play to our strengths and like talking about the things we know about, but if we were applying here for resource consents for marine farming aquaculture activities, either through the statute or the RMA, there is a statutory process for assessing how that aquaculture development would impact on fisheries resources and fishing, commercial, non-commercial, customary. And that's a process that says if it's assessed that the negative impact of the marine farming would exceed a threshold of impact on fishing, then there is a statutory requirement to negotiate and compensate. So again, I'd say that's an example of a situation where there is an adverse impact on my fishery settlement quota, but the protective mechanism for that is written into the framework, into the legislation that we're working with. That's all contrasted with this situation where we've got a decision-making framework which was not contemplated at the time of the fishery settlement or any of the land-based treaty settlements either. And that's why this new decision-making impact that could permit an activity that has such significant adverse effects is inconsistent with those settlements. And I think I'll leave it there, barring any questions.
No, I don't actually specifically have any questions. I will say thank you. That was quite robust in terms of answering our questions, so much appreciated, Justine. I'll just double check. Yeah, so kia ora. Thank you.
Thank you.
Right, next row.
I'm going to push the button and see if it works, but it didn't seem to. Is the microphone on?
We
No.
can hear you, so that must be working.
It's working great. Okay, thank you. Peter Anderson for Forest and Bird, and with me is May Downing. We're going to address four issues. One is the question of relevance, one is the consent requirements, one is the East-West link question, and the other question is feasibility. I'm going to deal with the relevance, the consent requirement, and the feasibility, and Ms Downing is going to address East-West link.
Could we have the actual question numbers when you do that?
Sure. So the first question is question one, which is what is the relevance, if any, of factual findings by the DMC on previous applications by the applicant? What this is really about responding to other parties that have reached different views to what we have. So we're not restating the submissions, but in paragraph 5 and 6 of their written submissions, TTR. Explain that it's a new panel and it's obliged to make its own findings. But then in paragraph 6, and we agree with paragraph 5, paragraph 6, the TTR say, for all the above reasons, no factual findings by either of the prior DMCs have any relevance to the present matter. We depart from TTR on that point. The Supreme Court decision, which they referred to as quashing the earlier decision, that addressed matters of law, and they actually referred to the factual findings of the DMC and included those in an appendix. So the notion that the factual findings were quashed doesn't stack up. And the second point is that it would be undesirable if we had a DMC in considering effectively the same material, reaching a different view without any reference back. There's no requirement on this DMC to be bound by it. But if it reached different views, then it would be undesirable to have one DMC saying this is having significant effects and this DMC to say different, without actually some kind of explanation of why that different view was reached. And there will be justifiable reasons for it, but to simply just say it's not relevant at all, I disagree with that submission.
So your dissatisfaction would arise if we disagreed with the earlier findings without explaining why.
Yeah. I mean, so if the previous DMC made findings about that there were significant adverse effects, and this DMC said that we conclude there are no significant adverse effects from this, then you'd have these two decisions which are contradictory. But then what I would expect or submit would be appropriate would be that the current DMC would look back and say, well, the DMC reached these views about, the 2017 DMC reached these views, and we differ for the following reasons. Different evidence provided, etc., but simply having two starkly different decisions out there, that I think would be undesirable.
I understand that.
The second issue I want to address is the consent requirement. Which is this issue about whether resource consents are required under the RMA, and the question of discharge and deposition. What our focus on is on Section 12 of the RMA, and so particularly Section 12(1)(d), which says no person may in the coastal marine area deposit in or onto any foreshore or seabed any substance in a manner that has or is likely to have an adverse effect on the foreshore or seabed. And so whether or not the discharge occurs in or out of the CMA doesn't matter. The deposition occurs within the CMA, therefore it contravenes Section 12(1)(d). That's the start point about that. Don't take a view on discharge whether a consent is required, but there's a firm view that consent is required for a deposition in the CMA.
So if we turn that around, are there any examples of whether there's an activity undertaken in the CMA which causes deposition in the EEZ, and where a consent has had to be secured for that plume extending out into the EEZ under that piece of legislation?
I cannot think of any examples. There may be, but none spring to mind.
Thank you.
I'll now pass over to Ms. Downing to address question
13. Thank you, Ms. Downing for Forest and Bird. I just wanted to take the time to briefly respond to a point by my friends for the Taranaki Regional Council at 5.13a of their legal submissions. They note that the relevance of RMA policy and planning documents to the application is limited by the location of the project being within the EEZ. Our submission is that it is not that limited, particularly in light of the observations of the Supreme Court, particularly the majority, spearheaded by Glazebrook, who acknowledged that the bottom lines in the NZCPS had to be taken into account. And these are set out, the correct references are set out in paragraph 40 of our written submissions, and the footnotes attached to that. So we were just wanting to point that out. And just while I've got the speaking stick, I thought I'd take the liberty to just briefly touch on a small point in relation to Ms. Member Lovell's query about kaitiakitanga considerations for the panel. I had done some thinking about that in relation to the query on habitats for significance for fisheries management, and it was at paragraph 62 of our written submissions where we make mention of the bottom line. So the Fisheries Act is also a marine management regime, and within that, at paragraph 62, we make observations about the senior courts consistently finding that the purpose of the Fisheries Act sets a bottom line. So the ultimate aim is to ensure sustainability, and whilst that might seem diametrically opposed to the other, so there's a twin purpose of ensuring sustainability but also allowing utilisation. An interesting facet of the definition of utilisation is that it also, and that's set out in Section 2 of the Fisheries Act, that refers to cultural well-being, and the footnote 29, I've referred to a decision by Justice Churchman, Environmental Law Initiative, and the Ministry for Oceans and Fisheries, and I just point the panel to paragraph 12 of that decision, where Justice Churchman acknowledges the definition of utilisation includes the concept of cultural well-being. And in that he notes that includes obligations of kaitiakitanga by iwi, hapu and whānau Māori within their respective rohe, and he also points to the definition of kaitiakitanga in Section 2 of the Fisheries Act. Pass you back to Mr Anderson.
Did you have a question?
Yeah, I do have one question, just around the statutory planning instruments that apply within the CMA, so like the New Zealand Coastal Policy Statement. Just wanting to confirm my understanding that your submissions are they apply within the CMA but they do not extend into the EEZ. Is that correct?
And so, yes, so they apply in the CMA insofar as effects generated by the activity will be felt within the CMA. Yes, maybe you don't because you remember the quote.
I think just to add to that, the one of the points the Supreme Court made, I think it was Glazebrook, but I'm not 100% sure, was this notion of, yeah, Justice Glazebrook, yes, Justice Glazebrook, yes, yes, sir. Justice Glazebrook made a point. I think it was Justice Glazebrook made the point that that there was synergy between the NZCPS and the EEZ Act. So the idea is that even though the NZCPS applies within the CMA, then looking across to the way in which that interacts in the EEZ, that's something to do to make sure the EEZ Act and the Coastal Marine and the NZCPS work together rather than contradictory. I can see you're thinking.
This is not for transparency. Thank you.
And so the last point that we wanted to address was this question of feasibility, and that's question 4, is the project's feasibility a relevant consideration? And we just wanted to respond to paragraph 12 of the TTR submissions, which they say feasibility isn't a relevant consideration. And what my submission on their paragraph 12 is that they've confused feasibility with viability, and what they say is correct about viability, but feasibility is a different thing. And so when we talk about feasibility, if they had said we are going to do this thing, which is going to be this seabed mining, and that is going to not have any impacts anywhere within the CMA, it would be open to the panel to say, well, that's not feasible. So feasibility is an issue insofar it comes to meeting consent conditions. So you couldn't impose a condition where you didn't think that the applicant could actually meet it. And that's different to the viability point that's been raised in paragraph 12 of the TTR submissions. And I have nothing further to say unless there's any questions from the panel.
Thank you, Mr. Next row.
Tēnā nō koutou. Thank you. I'm hoping to be at the 4-minute end of Ms. Inz's spectrum. I have 3 points to make. The first is to...
Please identify yourself and your organisation.
Horiana Uanestope, appearing with Beth Murfitt for Te Ohu Kaimoana Trustee Limited. Thank you, sir.
Thank you.
So 3 points. The first is picking up on my friend Ms. Inz's helpful examples in the context of question 21B and coming back to member Lovell's questions this morning. The only thing I would highlight in our submissions is we have addressed at least one of those examples at, just for your reference, panel paragraph 30, which is the undue effects test. So in addition to the detail that is included, or I understand is included in Ms Inz's submissions for Ngāti Ruanui. The next 2 points are in relation to question 10, and these are points that our written submissions do not address, so content to rely on our written submissions in relation to questions 11 and 21. The first point in relation to question 10 on treaty principles is just another case for the panel, which is Justice Palmer's decision in the line of Ngāti Whātua cases, so that's the number 4 decision, so bringing us from Justice Chilwell in 1987 to Justice Palmer in 2022, who's very clear that the treaty does not need to be directly incorporated to be relevant, just under general principles of statutory incorporation or interpretation. The second point on question 10 is seeking to be helpful to the part that Member Lovell has emphasised, firstly by endorsing the submissions of my friend Ms Inns, and secondly to hopefully add to them in the context of, I'm at risk of labouring this point, but of course when the panel is in the space of inconsistency, so if we're thinking about legal tests, the Crown has clearly identified that the panel can decline the application. So that's the only addition that I would make to my friend's submissions around existing interests, and to the extent there's a different legal test for inconsistencies with obligations under treaty settlements. Thank you, sir.
Thank you.
Thank you, sir. Matt Conway with Kira Parker for Taranaki Regional Council and South Taranaki District Council. I too intend to be at the shorter end of the spectrum. I have comments to make on questions 2, 5, 10B, and then the bottom lines question in 13 and 24. In terms of question 2, Mr. Slyfield this morning indicated a view that it's not open to the panel to find that an RMA consent will be needed. We've said in our written submissions on question 2 that the panel is not required to determine whether the application requires approval under the RMA, but I would submit it cannot be correct that it's not open to the panel to find RMA consents will be needed. For a start, that's because under the EEZ Act, section 59(2)H requires the panel to take into account the nature and effect of other marine management regimes, and specifically in terms of section 5, the panel, section 5 of the Fast Track Act, the panel does need to satisfy itself that the activity is not an ineligible activity. In that respect, to be clear, TRC and STDC do not say that this activity is prohibited in one of the ways referred to in section 5, so we're not saying it is ineligible, but I would support my friend Mr. Anderson's comment that section 12(1)D of the RMA is a relevant thing that will need to be considered in relation to the project in terms of whether sediment that is raised through the project in the EEZ is deposited within the CMA and therefore within the area covered by the Resource Management Act. If it is so triggered, then the activity status, in case it's useful, under the Taranaki Regional Coastal Plan would either be discretionary activity or a non-complying activity. The distinction being whether the sediment is deposited in one of the protected areas and that are recorded under the regional plan or not. And so there would be matters that would need to be considered, and provisions of the NZCPS, including policy 11, that may well be triggered under that too. So those are matters that will need to be determined, and the panel is in the perhaps tricky position of needing to work out to what extent they create doubt about the overall implementability of this application, bearing in mind that you have not, as has been identified, you have not been asked to determine any such application. So it could, it's not something you would need to directly make a finding on in my submission, but it may be relevant to that overall question, a bit like the feasibility one of whether these consents can be fully implemented if approved. On that point, and it was raised first thing this morning from the panel, and about the question of, I suppose, side winds and whether...
Excuse me, Mr. Conway, can we just, can you give us the rule numbers that you're relying on for those activity classifications, please?
Yes, they are rules 65 and 66, which cover deposition that's not provided for in earlier rules.
And that's the regional coastal plan?
Yes.
Thank you.
A question that was asked first thing this morning was whether any doubt about whether the activity could proceed might essentially be neutralised in terms of the benefits not materialising, and also the impacts not materialising. In general terms, that does seem a logical way to look at it, but I would respectfully caution against assuming that all such benefits and impacts might neutralise each other if there is a doubt about whether the activity could proceed. And I've been thinking about whether there's an example of that would assist in the context of the matters raised by those making comments on this application. One such example might well be that if TTR receives a marine consent for its activity in this area, it would become an existing interest in terms of having an activity that may be undertaken under the authority of an existing marine consent. So that would qualify TTR as having an existing interest. At that point, and this is a question of how far you go down this track, but it seems realistic that that might dissuade another potential applicant from making an application, or it might well, if they do make an application, mean that effects on TTR's existing interest might be material to the consideration of their own application. Now, that's a matter for weighing for the panel as to whether that would qualify as an adverse impact, but the definition of adverse impact under the Act in section 85.5 is broad, and it says adverse impact means any matter considered by the panel in complying with section 81.2 that weighs against granting the approval, and in turn the matters in section 81.2 include matters raised in comments which have covered all of the above types of things. So those are matters that may become relevant. So that's just a caution against going too far in terms of the neutralising component. Turning now to question 5 on that, comfortable that we've raised relevant matters in our legal submissions. What I would just want to draw the panel's attention to is, in terms of other recent comment on this yesterday, the Waihi North draft decision was issued by a differently constituted panel chaired by Sir William Young, KC, and in that case there are some comments in part F of that draft decision that, in short, I would submit reinforce the position that generally seems to be taken in submissions here, but I will I will refer you to the relevant paragraphs in case it's useful for ease of reference, and I'm happy to have that part sent through if it assists too. Yes, thank you. In that case, yes, in Part F, and it's Part F of the draft decision, and in that part it's paragraphs 34 to 37. There is also a note at the end of paragraph 91 in that same part about how significance is to be determined, and I'll simply leave that in case it's of use or interest more generally in relation to this matter. And it really, the key point is it's an indication of scale, and I think that's consistent with what we've otherwise said to the extent relevant in our submissions here.
Can I just ask you a question which has really only just occurred to me, and I'd say this with respect to those who may have been on panels that have already made decisions under the Act. Obviously, I use the word judicial advisor, the judicial committee would suggest that panels should, so far as is reasonably possible, try to reach a common view on some of these legal questions. So it would be, I think, unhelpful to the scheme or to the operation of the Act as a whole if panels simply went off and did their own thing and paid no heed at all to other decisions of other panels on similar questions. I mean, do you agree with the approach that we should, where possible, take into account and agree as far as possible with other panels' decision on these general questions of law? Is that the sort of approach you say we should take?
Yes, sir, I think it would be beneficial. I don't think you're bound to in the way that you would be perhaps if there was a decision from a higher court that had made a clear finding on interpretation. But in the absence of such, it is a situation where, as these questions the panel's devised highlight, a call is needing to be made on what some of the provisions in the Act mean. And in some cases, certainly we've looked, as with the reference to the Meridian case earlier, we've looked to find useful wording from other regimes perhaps to describe what some of these obligations mean. Here, obviously, it's the same framework, but naturally in this case it's not under the EEZ Act in terms of the Waihi North decision, but it is helpful, and I think it may provide wording that if this panel agreed with, it could adopt, and that would have the benefit you've just described.
Yes, right, I understand that, thank you.
Turning to question 10B, I'm generally comfortable with what's been raised by my friends. The Regional Council and District Council do see that the existing interest and obligations arising under a treaty settlement in terms of the two different provisions referred to in this question relate to the same subject matter, but the role of each legal requirement is different and needs to be considered on its face. And I don't think I need to say too much more on that other than just reinforce the reference to section 85(1)(b) that has already been made today, that indicates that if a panel decides that granting an approval would breach section 7, then that is a ground on which the panel must decline. I don't make a submission about whether you're in that position here, and I do leave submissions on the detail of that and of the nature of those existing interests to those who are asserting them, and I respect those, so I'll leave you to consider those, but just wanted to highlight that point. Finally, in terms of bottom lines, questions 13 and 24, I agree with what Mr. Enright indicated just before he signed off about those. The answer is in section 85(4) of the Fast Track Act, and it's really that word solely. That section does not say other enactments or documents like the NZCPS cannot be influential in a decision, and it would improperly apply them in my submission if you were to conclude that they couldn't tip the balance. In fact, the role that often those documents have and are recognised as having is identifying particular locations of environmental sensitivity and the degree to which public processes under the RMA have determined those warrant protection, and so they inherently reinforce judgment calls made about the level of protection that might be warranted. And as Mr. Enright said, it would seem very rare, and we're not in that situation here, where the only thing possibly that is being triggered is a bottom line under one of those regimes, which would get you into the Section 85(4) territory. Here it's really a matter of, I think, being able to weigh all of those things and being guided by those other statutory documents and their bottom lines, which may well be influential. And just to confirm, appreciate the point my friend Ms Downing made in relation to our submissions, and I just confirm I agree with her that we were saying essentially in paragraph 5.13 of our submissions, the fast track purpose and decision making provisions inherently modify how those RMA provisions and documents apply, not that they can't be influential. And to reinforce that, I think the Supreme Court's decision at paragraphs 181 and 182 are very clear about the relevance of RMA documents to an EEZ activity. And paragraph 187 is also instructive in that respect, because that confirmed that there was an error of law in not assessing whether the proposal would produce outcomes inconsistent with the objectives of the RMA and the NZCPS within the CMA. And those are the only comments I was planning to make, sir.
Yes, can you hear me? Yes. Thank you. Ms Hazen and Ruby Hazen and Duncan Curry for Chasm and Greenpeace. We will be speaking on questions 5, 10, 20 and 24, which is the economics, climate change and some of the statutory framework questions. On question 5, around economics, the joint witness statement for the economists, there seems to be general agreement that it is a net and not gross assessment, but disagreement around non-economic versus, or non-market versus market costs and benefits. We would say that the Fast Track Act gives some guidance as to whether or not these non-market costs and benefits are also included within the definition of benefit. Section 22 of the Fast Track Act requires both non-market and market environmental and social factors, and these must be responded to in the information requirements for both listed and referred applications under Section 13(4) of the Fast Track Act. You can also gain some guidance from the RMA definition for benefit, which includes benefits and costs of any kind, whether monetary or non-monetary. And I think the last point on this would be that the Trans-Tasman Supreme Court decision, which looked at just the Section 59(2)(f) consideration of a cost-benefit analysis. Section 59(2)(f) refers to economic benefits, and we would say those are only the market considerations. And here we have benefit, not the use of economic. So that's the broader sense of both those non-market and market considerations. Question 20. And that's the question relating to Section 62 of the EEZ Act and whether that's a standalone ground for declining a marine consent. And then the second question, or are the panel's powers to decline confined to Section 85? Just on further consideration, I think in our written responses we initially said, no, it's not a standalone ground, but we now say yes. And that's on looking specifically at the wording of Schedule 10, Clause 6.2. And that wording refers to the panel must take into account, and it's referring to 62(1)A of the EZ Act, where it would normally require an application to be declined, but must not treat that provision as requiring the panel to decline the approval the panel is considering. The submission is that here the Act is explicitly setting out where a mandatory obligation to decline under the EZ Act doesn't bite on the panel. And the corollary of that must be that the other provisions, the one Section 62(2), which sits right underneath, can provide a discretionary basis for the panel to decline. So that Section 85, the pathways under Section 85 are not the only ones, and that is recognised in Schedule 10, Clause 6. In terms of Section 81(2)(f), that says that the panel may decline the approval only in accordance with Section 85. We would say that that needs to be read in light of the purpose of the Act, but also that where you have a pathway to decline, as long as it is not inconsistent with Section 85, then you are not contrary to this bar in Section 81(2)(f) that the panel may only decline in accordance with. We say that has to be the case because otherwise you end up with a rather illogical outcome. The Fast Track Act doesn't allow for any provision for a discretionary power to decline where you have inadequate information. And if the only discretionary power sits on Section 85(3), then you have to make a finding that where you have inadequate information that demonstrates sufficiently significant adverse impacts. And that to me is how can you, just in the Supreme Court finding where there was inadequate information on the exact same application to determine material harm, how can on this information you can also make a finding of sufficiently significant adverse impacts? That would be illogical in our submission. There must be a pathway for the panel to decline based on inadequacy of information. The other indicator would be that where a applicant applies but does not demonstrate significant regional or national benefit, they have not met the burden under Section 3, and Section 85(3) doesn't necessarily require that the panel decline in that case. So Section 85(3) doesn't refer to significant national or regional benefits. It only refers to regional or national benefit. So your proportionality assessment may allow, or arguably it shouldn't, but it allow an application that doesn't meet that high threshold, but the adverse effects are not out of proportion to the benefits, and you still don't have a basis to decline under Section 85(3). So there must be other pathways that are not inconsistent with Section 85, but where you have an application that fundamentally doesn't meet the purpose of demonstrating significant national or regional benefit, so should not be facilitated through this fast track procedure that can be declined on that basis or on the basis of inadequate information. Just a comment then, I think that on bottom lines, and that would be, I think, question 24, that for the other mandatory requirements under Clause 6, notably Section 10 of the EEZ Act and Section 61, we say that these should be given substantial weight and determinative weight, that it would be very difficult finding to say that an application that fails to meet the very purpose of the management regime that it sits within, i.e. Section 10 of the EEZ Act, but is so beneficial it still should go ahead. That to me is not, that would be out of alignment with both the purpose of the Fast Track Act and the purpose of the EEZ Act. And a finding of breach of Section 10 of the EEZ Act should be given substantial weight in the proportionality assessment. The final comment from me probably is just on feasibility. I generally agree with my learned friend's comments here for forest and bird, but also would say that if the application, there's been some evidence given through the Sanifex report and for evidence produced by Chasm and Greenpeace that there is some issues around the feasibility of the extraction of vanadium from the sand and the costs of washing the sand and producing the volumes of metal that TTR is relying on. And that's a technical issue that does go to whether or not the benefits that TTR say will accrue will actually accrue. If there's no questions from the panel on those, I'll pass to Duncan Curry to speak to the climate change point.
Thank you, Ms. Howard.
Thank you, panel. We just have a very brief, sub-4-minute observation on climate change and questions 7 to 9. Firstly, we fully agree with Mr. Enright's comments, and we just want to point to our submissions on the question, and in particular to draw a line between environmental protection and climate change. And we note that Climate Justice Taranaki made similar points in their comments. It seems to be well accepted we're not in the territory of Section 59 5B of the EEZ Act and the effects on climate change of discharging greenhouse gases into the air. You know, we're talking about different impacts here. What we do want to add is that since the Supreme Court decision, a landmark advisory opinion on climate change was delivered by the International Tribunal for the Law of the Sea, which is an international court in Hamburg. And that opinion strongly linked environmental protection, and in particular Article 192 of the 92 Convention with climate change. And in our comments, we quoted that the obligation under Article 192 of the Convention to protect and preserve the marine environment has a broad scope encompassing any type of harm or threat to the marine environment. Under this provision, states parties have a specific obligation to protect and preserve the marine environment from climate change impacts and ocean acidification. So our point here is simply that as a matter of weighing the climate change effects, their relevance to environmental protection, which was recognised also by the Supreme Court, is a relevant consideration. And so finally we want to just point to the Supreme Court citation of Article 192, which is its obligation to protect and preserve the marine environment, and the Supreme Court linked that to Section 10(1)(b) of the EEZ Act, and that's in paragraph 101 of the Supreme Court decision. The Supreme Court said that the Law of the Sea Convention provides support for the proposition that Section 10(1)(b) imposes a heightened threshold in favour of environmental protection. And that was Justices Young in France. So, in closing, we say that the panel should likewise strive to reach an interpretation of the Fast Track Approvals Act, which is consistent with New Zealand's obligations, and pay particular attention to Section 59 of the EEZ Act, in paragraphs D, the importance of protecting the biological diversity and integrity of marine species, ecosystems and processes, and in paragraph E, the importance of protecting rare and vulnerable ecosystems and the habitats of threatened species. Thank you, panel.
Thank you. Mr. Gardner-Hopkins.
Thank you. If it's acceptable to the panel, my preference is to stand when I address the panel. Thank you. Look, I just, and I'm grateful for the submissions made by other council. I don't intend to cover ground that's been covered already. The one question I wish to address the panel on, are the two related questions, 2A and 2B, in terms of the relevance of Resource Management Act approvals. And I think just for the record, I just want to confirm I'm here giving representations for Ngāti Mana Hiakai and Ngāti Tū. And I'm speaking to aspects of the submission that was filed by Ms. Rongo and Ms. Black, just so that that is clear. And look, an aspect of that submission addressed whether or not this application included an ineligible activity. And I'm grateful to Council for the Regional Council for clarifying their position, at least, that this application doesn't include an ineligible activity. And I think, perhaps with some reluctance, I tend to agree with that position. And I just wish to clarify why that is for the assistance of the panel. And of course, this is a key question because under Section 85 of the FTAA, the panel must decline if an application includes an ineligible activity. And that is defined in Section 5, and the relevant part of that Section 5 definition is an activity that is described in Section 15B of the RMA and is a prohibited activity under that Act or regulations. And so it's not just enough to be an activity described in 15B of the RMA, it has to be prohibited. And so, look, I have done my best to double check the provisions of the Regional Coastal Plan. And as I understand it, discharges in terms of activities that would be captured by Section 15B are either discretionary or non-complying under Rule 13 and 14 of the Regional Plan. And so in that case, the discharge is something that is controlled under the relevant Regional Coastal Plan through a discretionary or non-complying consent status. So I think that gets to the point where the activity doesn't include an ineligible activity. But I would, I guess, urge the panel to satisfy itself that that logic and chain of reasoning holds and make a specific finding that it does not include an ineligible activity. And the only other, I guess, comment that I would have is subject to that finding, the panel, as I understand it, does not need to make specific findings as to what RMA consents may or may not be required, but it would be entitled to, as part of its consideration of the relevance of the RMA as a other marine management regime. So it may be relevant to the exercise of understanding that regime, to understand what consents may be required. And there is obviously the somewhat vexed issue as to whether if the discharge is occurring within the EEZ, whether consents under the RMA are required for deposition. Certainly my clients say so, There is also potentially a question of if the discharge is occurring in sufficient proximity to the coastal marine area, and as I understand it, the application site effectively abuts the coastal marine area, and so there will be some discharges very, very close to the CMA. There is a question as to if the discharge is occurring, centimetres or metres away from the CMA, and it is continuing in the plume into the CMA, is there actually a discharge as well into the CMA, not just a deposition? And unless there's any questions from the panel on those issues, that was just what I wished to assist the panel with.
One moment. Is above my pay grade, Mr. Gardner Hopkins, so I'm taking advice. So, Mr. Gardner Hopkins, section 5(1)(L)(2) of the FTAA refers to the actual regulations in relation to an eligible activity, and you've mentioned, I think, something about the plan.
Yes.
And is there a point there that you need to address?
So in terms of the regulations, I understand there are relevant regulations, but they are permissive, as I understand it, in terms of addressing standard or common discharges from ships and offshore installations, stormwater, grey water, matters like that. And so those regulations, as I understand it, are enabling. I don't understand those regulations to prohibit the relevant discharges.
Thank you. Yes.
Can you just give me the rule citations again that you rely on?
Yes, Rule 13 and 14 of the Regional Coastal Plan. That they're the catch-all other discharges not otherwise provided for in the earlier rules.
Thank you. No, thank you. I think that's sufficient. Thank you, Mr. Gardner.
Thank you.
Kia ora, Mr. Conway. I just had a question following the submissions you have just heard. Sorry, I'm very quiet. That's why I need these. Just on the point around the discharge from source and the effectively going into the CMA and therefore triggering the question we have in terms of 2 around requiring approval under the RMA. You've heard the submissions thus far. Do you have a view as on behalf of the councils as to your perspective?
Is that specifically in relation to whether the activity would constitute a discharge within the CMA as opposed to a deposition? Have I understood that correctly?
Yeah, it's that source question. So the source might be in the EEZ, but is there a corollary which says that effectively we then need a consent in this, if the impact affects the CMA, that we need a consent in the CMA?
The approach that has traditionally been taken under the RMA is that the point of discharge is where the contaminant leaves the effective control of the discharger. And so if that is purely within the EEZ, then my starting point for that analysis would be to say that the point of discharge is within the EEZ, and therefore anything under the over the line in the CMA, you'd be looking at deposition rather than discharge rules. The challenge can be that it's very difficult to draw strict lines, but that is the traditional starting point for that consideration, if that assists. And I can probably find a case that I think it's McKnight and Biogas, I think, that says that, if my memory serves me correctly. I'm sure other councils.
Check that authority for us, please, and send us a note.
Yes, I will do, sir.
So just further to that, do you agree with the contention that the activity is not something that cuts across 15B?
In short, yes, because 15B of the RMA prohibits certain discharges within the CMA, and on the basis of that reasoning, I don't think it's correct to say that this would be a discharge in the CMA if it's occurring within the EEZ.
And the next row from the back.
Thank you. I think we've got a microphone issue. Oh, no, we're working now. Thank you, Sir. Ferguson for Te Tōpuni Ngārahu. As you'll appreciate, given the limited scope we were given in terms of legal submissions as they came after the others, to the large part we've indicated in our written submission that we support relevant submissions of other parties, but there were a couple of supplementary areas where we did add some comment, and they are matters within particular scope today. So I wanted to touch briefly on the point you've just finished on, which is 2A, question 2A, then also questions 10, both limbs, and finally just question 21A relating to the judicial or quasi-judicial question that was traversed earlier. Just in relation to the first question, this issue about the interplay with consent required under the Resource Management Act, and that was a matter where in paragraph 11 of the Te Tōpuni Ngārahu submission we did note those two rules that Friend Mr Conway's referred to, being rules 65 and 66, which clearly do apply to deposition of material on or under the foreshore or seabed within the CMA, and I can agree that those would apply regardless of where the source of that deposition was. So anything arising within the EEZ, if it is being deposited within the CMA, in my submission triggers those rules and those requirements. In that regard, they're either discretionary, that applies generally to any deposition of material within the open sea, but it becomes non-compliant when it's in an outstanding value area. And in that latter respect, in terms of the outstanding value areas, they include in Schedule 2, I think, or Schedule 1 it might be, of the Taranaki Coastal Plan, Project Reef and the North and South Traps. And those are both areas that were expressly referred to in the course of both the DMC decision, but also by the Supreme Court, referring to the traps, as it was called in paragraph 185 of the Supreme Court's judgment, and Project Reef in paragraph 288 of the Supreme Court's decision, noting that there were findings of adverse effects in relation to the traps, and potentially effects of a more minor nature in relation to Project Reef. And usefully, and I think my friend for Fish and Game referred to this earlier, right at the final page of the Supreme Court judgment as an appendix, there's a helpful Appendix 3, a diagram. It was prepared by iwi parties, but it does list the DMC effects, findings on effects, and shows a map of the proposed mining area, and then those two and a number of other areas of the traps in the Project Reef and their distances, and then refers helpfully to the paragraphs of the DMC decision in relation to Project Reef. A significant effect by the DMC at paragraphs 350 and 970 of its decision. Major effect on Project Reef at paragraph 952. And the traps, sorry, I had them wrong way, the traps, minor effect identified at page 900, paragraph 970 of the DMC decision. So this is a very real impact that's been identified here. And I think putting to one side the issue of the resource consent itself that we would also submit needs to be applied for by the applicant, and whether the fact that that resource consent still needs to be sought, in our argument at least, is a relevant matter for the panel. I think I'll just make two comments. First, at the very least, it's a contingency, and in my submission based on the material that's before the panel, that contingency should be expressly recognised and referred to for the avoidance of doubt. But secondly, even though it's not for this panel to determine in some kind of de facto way the outcome of any such resource consent application, it's quite clear that effects of this activity must also be reasonably considered where they occur within the CMA as part of the overall assessment of whether this activity and application should be approved. So it's a bit like saying, well, if one says that one doesn't look at effects in the CMA, one only looks at effects within the EEZ, then you could must apply that equally to benefits. And of course, many of the benefits, when looked at economically and otherwise, are not benefits within the EEZ. They're benefits to people and other economic benefits that apply within the nation as a whole. And so drawing these lines between the EEZ and the CMA in some kind of artificial way and saying, don't worry, we can deal with all that if required in a resource consent application, in my view, is not the end of the point for the panel, and the panel must grapple with the evidence and issues that arise naturally in that space, and those are effects of an environmental nature, effects in relation to fisheries and the fisheries settlement, which those fisheries and that quota under the settlement, needless to say, exists both within the CMA and within the EEZ, and of course the implications for both existing rights and treaty settlements for iwi. So I just wanted to make those points in that regard.
Before we move on from there, were those findings of the DMC you referred to founded on evidence which is also before this panel?
I'm happy to reflect on that and advise the panel. Given my very late instruction, I haven't had the opportunity to delve to that level of detail. But
because if you want us to have regard to them, it would be difficult for us to do that if the DMC was considering materials not before us. Wouldn't it? I mean, is that... I suppose I should ask that question. How could we have regard to findings of another body, another panel, founded on evidence that we're not considering?
So, if I may, the evidence with regards to the plume modelling, our understanding is that has not changed, and therefore the flow-on assessment of effects to biodiversity effects, which relies on the plume modelling, also has not changed. That has not been updated by the applicant.
You're confirming that the evidence considered by the DMC is evidence that we're required to consider?
It's the same, yes.
Thank you. I'm grateful to my friend in that respect for that clarification. I then wanted to turn to question 10, and apologies to the panel. I fear that the second limb of that question may have been dropped from a number of responses, because I think it was added between the original minute and the notice of hearing, and I suspect it wasn't always picked up on, and certainly I was guilty of that oversight. I looked at the question numbers and saw it hadn't changed without noticing there was a second limb to it. But I think the matters can be fairly addressed. I think they are interrelated to some degree, the two limbs, and perhaps if I just briefly touch on the first limb of that question. And I know this is a matter that was addressed in the written submission for Te Tōpuni Ngaruhu, paragraph 17 and 18. But in terms of the relevance of treaty principles, cultural values and kaitiakitanga, they are all, in my view, matters that appropriately are imported in and may be implied in as relevant considerations. They are interrelated in that respect. There is no preclusion, the absence of an express obligation, for example, to give effect to give consideration to treaty principles, does not preclude the consideration where those are relevant, and that's quite clear from cases that others have mentioned, such as Barton Prescott. But it is closely linked always to the subject matter of the legislation in question, as that case determined in relation to those matters, and obviously, as we have seen in other cases where matters relate particularly to the rights and interests of iwi, and where we're dealing with this legislative scheme and the consideration of activities with effects on the environment, and I think more tellingly where we have clearly identified intersection of both treaty settlements and existing interests of iwi and hapu in a range of capacities, where those things are express mandatory considerations, then the importation of treaty principles as a relevant consideration is both reasonable and appropriate. So that gives you the focal point through those mandatory relevant considerations of the panel, that in my submission treaty principles are naturally able to be considered as a relevant consideration by the panel alongside those matters, given the subject. In that regard, I just wanted to touch on the fact that treaty settlements by their very nature aren't simply the specific mechanisms or the specific requirements that might be to give consideration to a particular matter, for example in a particular area, that would be viewed if one stepped through elements of settlement redress, but necessarily treaty settlements are founded on the Crown's express intention to fulfil, and where previously breached, correct its obligations under Te Treaty, must necessarily be considered and upheld with reference to the principles of Te Treaty, and thirdly, acknowledge and recognise the intrinsic and holistic relationship between iwi and the natural environment, including coast and sea, and both innately and in many cases expressly incorporate the cultural values and tikanga rights, interests and responsibilities of iwi, including kaitiakitanga. So when one's looking at those matters, the relevant principles of Te Treaty and tikanga notions such as kaitiakitanga are also within the frame of treaty settlements and acting consistently with treaty settlements, as those treaty settlements commonly contain significant acknowledgements even where they don't necessarily have legal weighting into statutory schemes, where the Crown has acknowledged those relationships, and they do so particularly in the case of my client and also Ngāiwi o Taranaki, in terms of the relationship of Te Kahui Tupua extending out into the CMA in that respect, and obviously the source of the iron sand material in this particular case. And so there are a range of provisions, for example, in that legislation acknowledging that close relationship as a matter of tikanga, and the reciprocal obligations that iwi and others in the Taranaki community have to those value sets in terms of ngā pou whakatupua, that's in section 19 of the Act. And so those matters are all part of the fabric and intrinsic elements of the treaty settlement, and consistency with those naturally arises and brings with it the issue of implication of consideration of kaitiakitanga, treaty principles, and cultural values. So those things are all intricately interwoven, and I think it would be, this is very much legislation where, in order to read those things in their fullest and natural way, one necessarily has to touch on and draw from reference to cultural values, kaitiakitanga and treaty principles. They come in implicitly, and even if they're not mandatory considerations, they're at the very least discretionary relevant considerations. And in my view, it would be reasonable and appropriate in the circumstances for the panel to treat them accordingly. In terms of the second aspect, which wasn't addressed in the written submission, in terms of existing interests as grappled with by the Supreme Court and treaty obligations in terms of the specific provision in this legislation, in my view there isn't they're not discrete matters in that respect. I think they are coexistent layers, and there are fundamental interrelationships between treaty settlements and treaty settlement obligations, and the nature of what treaty settlements represent for the reasons I've just indicated, and the existing interests of iwi and hapu of Taranaki, which exist as a matter of tikanga and kaua, and are manifest and not limited by the statutory frameworks in which they might operate. So even where there are artificially created lines drawn by within any legislation, including the line between the CMA and the EEZ, those lines do not constrain the nature of the existing interests of iwi. And so if, for example, some settlement acknowledgements might end at the end of the CMA, that does not mean that the iwi values and interests stop at the end of the CMA. It just means that's where the Crown has grappled with them in the context of the treaty settlement, but they still manifest as existing interests beyond and out into the EEZ. And so it's a holistic and integrated whole in that respect from a perspective of iwi and hapu. And therefore, while there are things that perhaps fall in one camp and not the other to the large extent, in my view, there's a significant and material overlap between those. And it's probably not useful to kind of decompartmentalise them in that respect. I think the analysis is a seamless one in a sense. So those are the comments I wanted to make in relation to that. And the final point is just an observation, not wanting to repeat matters that my friends have helpfully addressed in relation to question 21A, which is the odd second limb and seeming inconsistency of the treaty obligations provision, and that it doesn't apply to a court or persons exercising a judicial decision or decision of a judicial nature. Just observe that having been closely involved, I'm pleased that my friend Thinwood identified the fact that this arose originally out of submissions made by the Solicitor General in relation to the foreshore, or Chief Justice, I think it might have been actually, Chief Justice, my apologies, in relation to the Natural and Built Environments Act in the first instance. Ultimately, that didn't manifest in any changes to that legislation, those submissions, but this the point clearly was concern about those types of references, in that case to Te Treaty o Waitangi and all the principles of it rather than treaty settlement obligations, but those affecting or applying to the court when making its procedural and other administrative decisions of running the court. And that was a matter that was particularly identified in that submission, that somehow in that case, giving effect to the principles of the treaty was the concern that the court, in calling a judicial conference or the way in which it conducts itself, would somehow have to give effect to the principles of the treaty at every limb. And I understand that was the rationale behind that. And I think what we've seen come through into this with respect, and it's not commented on in great detail apart from the reference and hint that my friend's already made to this provision dropping into this Act, and also one other Act. There is exactly the same qualification I have identified in Section 11 of the Hauraki Gulf Tikapa Moana Marine Protection Act 2025. And so that also has this general obligation in relation to treaty settlements, and then has a qualifying Section 11.2, which says it doesn't apply to a court or person exercising a judicial decision-making power. In that regard, the Director General of Conservation has a power to make various permitting decisions under Part 3 of that Act, but then the court also has a whole lot of punitive compliance and other penalty powers in the back of that Act as well. And it's quite clear, again, a bit like the inconsistency that's been identified on the face here, or the tension that the Director General, among the factors he has to expressly consider, the rights and interests of iwi and hapu, including kaitiakitanga, etc. So again, a complete tension between that and the fact of having to, if it was suggested that somehow that ruled out and giving effect to treaty settlements when they address those very issues and are in part reflective of the rights and interests of iwi and of matters such as kaitiakitanga. So I think, again, the clear intent is that it's not intended to apply to the Director General in that case. There doesn't appear to be any commentary on that. That clause was introduced at Committee of the Whole House stage, so there's no select committee and no material debate that I can see on that issue. But in the case there of the Director General and the case here of the panel in my submission, clearly it's not intended to apply. And if it was intended to apply, then the panel wouldn't be able to discharge the express obligations it's got under other provisions relating specifically to treaty settlements. So those are the submissions I wish to make today. So thank you for the opportunity.
Appreciate your help. Next. Oh, question.
Kia ora, Mr. Ferguson. If you can just help me, I just wanted to unpick, and you're the one blessed with the question after hearing a number of submissions on this point. I understand the discussion around treaty principles and kaitiaki, etc., in terms of the wider subset, the wider context of where a treaty settlement has come from, with obligations sitting as a subset of that. I understand what's been articulated, but I guess perhaps turning it on its head, recognising that we are dealing with Section 7.1, and that does speak to obligations. So do you perceive in this amorphous of intertwining that there are there any constraints, I guess is what I'm asking, in terms of that distinction between treaty principles and treaty settlement obligations, given we're dealing at Section 7.1 with obligations?
Yeah, it is an interesting question, and it doesn't say uphold either. It doesn't say uphold treaty settlement obligations. It says consistency with, and that's a much not say fuzzier, but it's a broader church in a sense in that regard. And I think, the one judgment we've got of utility in that is the one that my friends have already referred to, which is the decision of His Honour Justice Bolt in the Te Oko Kaimoana case, which clearly what was found to be an implicit obligation in relation to that settlement was not expressed on its terms at all, but it was about the steps which undermine the integrity of that settlement are, in that case, found to be in breach of, not simply inconsistent with. And I think that is my view in relation to treaty settlement obligations, that while one could go through a tick box exercise in relation to particular mechanisms, there's a fundamental issue of the relationship and the integrity of that settlement and how that is impacted upon by activities and applications of this nature as they impact upon those iwi. And that's why there's a bit of a challenge there, because there are some limits in terms of potentially where the extent of that treaty settlement might operate physically, because of the way areas of interest and other boundaries are put in place. Some of those mechanisms, for example, a statutory acknowledgement applies into the RMA, so therefore it's within the coastal marine area rather than the EEZ. But necessarily the rights and interests of those iwi and hapu, which manifest the very same things that those statutory acknowledgements are recording, carry on into the and beyond in that respect. So I think, you know, there are stronger arguments to be made in my submission in terms of this interplay with effects in the CMA in particular for iwi and hapu, but on that point of consistency, but in terms of existing interest, they manifest and extend right throughout. And I think, you know, so that's why I say that there's not a clean demarcation in that regard. And even if there is some form of demarcation within a treaty settlement, I think the existing interests pre-exist, pervade through and extend beyond that settlement. And again, the relevant considerations that I say can be imported in and implied into this legislation touch on both of those matters. It's probably not a clean black and white answer, I'm afraid, but it's probably the best I can do. It's a challenging area due to what can only be described as the kind of the odd legislative gymnastics that that Parliament has seen fit to charge or impose on us all, I think, where everyone is faced with the same challenge, whether one is the applicant, a submitter, or the panel. And it's you know, it comes back to that point. If this was intended to be a one-stop shop, as someone pointed out, it's a very awkward and clumsy way of doing that, and it's not effective for the very many reasons that have been identified. Kia ora.
I will speak up. This may be for Tohukai Mona. We assume the Tokum case hasn't been appealed?
That's my understanding. I can just confirm that, but that's my understanding.
Please.
Yep.
I'm very short, so I will stand. Tēnā koutou, Ms Walker, for Te Kāhui o Rauru and Te Korowai o Ngā Ruahinerangi. My friends, and I'm very grateful to them, have addressed most of the matters that we would have otherwise addressed, and that is because we generally take a common position, particularly for the iwi and hapu of Taranaki, in consort with Te Hukai Moana, obviously, who represent the fishery interest, and my friend Mr Ferguson with Te Tōpuni Ngārahu. So my points will be brief, possibly briefer than Ms Irwin Easthope, and questions 1, 10, 12 and 19 are really the focus, and very briefly. So in relation to question 1, and this has been well covered, and I don't really want to take the panel any further in terms of the argument, but just to note that the findings that the DMC did make, and we say have not been impacted or changed by any other material that's been brought before you. We're very clear about impacts on each of the coastal domains of Ngā Rauru and Ngā Ruahinerangi, and that's both within the EEZ and the CMA. And as you've heard from Mr Ferguson, that distinction, and you would have heard it a number of times from the representatives themselves from the iwi, that distinction is not something that exists in Te Ao Māori. It is artificial, and it is for the purposes of these regulatory frameworks that govern those spaces created by the Crown. And that point is well made, and this ties into question 12 in the kaitiaki plan of Ngā Ruahinerangi, which is available to you. And they cover in some detail in that plan the iwi's views on the EZ framework, but also that sets out from their perspective the holistic and interconnected nature of the entire domain of Tangaroa without any disruption between the EZ and the CMA, at least in their worldview. So you've got evidence before you of those impacts. The DMC found significant adverse effects in a number of spaces, and the evidence that you have before you in these proceedings from the iwi themselves endorses that and sets out clearly that this application will disrupt the balance within Tangaroa, and that evidence is from a number of parties, including Mr. Tūrama Hāwira and others. So you've got the base evidence, but you've also got additional and updating comment that's been brought before you by the iwi in these proceedings. Which leads us into question 10, which I think may have been question 9, but we'll stick with 10, which is, I'll call it the member level question. What is the relevance of the treaty principles, cultural values, and kaitiakitanga, and then of course the second limb? And we were one of the parties that did not address the second limb, but we fully endorse what Ms Inns has said this morning in relation to that second limb. And what I will say in relation to all of those things, and this relates both to treaty principles but treaty settlements as well, and my friends have touched on it, treaty settlements are carefully crafted. They are enduring. They take years of hard work, of mandate, of bringing the people together, of being voted on by the people a number of times through hui, and also a voting and ratification process. And so what is in those settlements is something that this panel should carefully consider, because they are not fast-track processes. They represent not only the 170 years of grievance, but they represent, you know, the years of negotiation between iwi and the Crown, and the toing and froing that occurs in that situation. And the thing that occurs to me, and it goes to your point, Your Honour, about your desire to see some sort of, well, not the desire, but the desirability within this framework of the Fast Track Act of having consistency across decisions, so that we don't dealing with panels going off in all different directions on these points of law. On the issue of treaty settlements and the other issues that are raised, particularly by the EEZ provisions, what you have before you is effectively a novel proceeding in terms of the fast-track decisions that have been heard to date, I would say. For example, the Waihi North decision that was issued, the draft decision issued yesterday, was not one that engaged heavily with treaty settlement matters, because there aren't a lot of treaty settlements in that area. What you have before you is a very different scenario. You have an application that is a decade in the making in terms of the background to it. You have a number of iwi and hapu who have given extensive comment and representation around treaty settlement, around kaitiakitanga, certainly for Ngā Rauru and Ngā Ruahine, around specifically Ngā Raurutanga, which is recognised in the Ngā Rauru Deed of Settlement and in their Settlement Act, around Ngā Ruahinetanga and their connection to the domains of Tangaroa and Atua, again recognised explicitly in the Ngā Ruahine Deed of Settlement and in their Settlement Act. So you have before you a significant body of information and submissions that other panels have not had to grapple with. And so without putting too much burden on you, but the iwi in these proceedings are saying to you, this is significant, this is a big application, this is complex, but actually we have given you everything we are able to give you in terms of our ngā raurutanga, in terms of our ngā ruahinetanga, to assist you in reaching a decision and weighing up the things that you need to weigh up under both the Fast Track Act and the considerations under the EEZ Act. And we say, obviously, a significant part of all of that is your consideration of the Ngā Rauru Claim Settlement Act, the Ngā Ruahine Claim Settlement Act, and of course all of our interests in the Māori Fisheries Act, and we fully endorse what Ms Irwin Easthope has brought to your attention in that regard. So that's probably all I have to say on that point, but that does lead me, and I'll just sort of conclude on this point. Question 12, tied into question 10 obviously, iwi environmental management plans and their relevance. I endorse the comments that were provided by Mr Gardner-Hopkins in this regard, and obviously we provided our own submissions on this. They stand in their own right. They are, you have them before you. All of the plans that have been provided to you contribute alongside the other evidence that you have to explaining all of those elements that I've just covered that you need to consider. So the Treaty of Waitangi settlements, they're set out, they're addressed, explanations of those are provided by the iwi themselves in those plans. They constitute evidence of the existing interests, both in tikanga terms, but also evidence of tikanga as other applicable law. They set out how iwi themselves apply tikanga across their rohe. Examples of that include rāhui that are currently in place that prevent the taking of particular kaimoana, and the circumstances in which future rāhui might be appropriate. So those plans are evidence and material that will be of use to you in assessing each of those elements under the two frameworks that you're considering within the overall fast track scheme. And I guess just to end on this, and it would be remiss of me not to, given I've just mentioned tikanga as other applicable law, but for the iwi of Ngā Rauru, Ngā Ruahine, and may I say all iwi of Taranaki, given the fact that they collectively attached Te Iho Tā Ngaingai to the cultural witness statement that you received last week, which is a powerful and enduring statement of kotahitanga amongst the iwi. Sort of circling back to my original point really, which is the division of these domains for the purposes of these various frameworks. And you'll see it, I think, in Ngā Ruahine's response to the request for information about benthic habitats, minute 14. They conclude there with a statement about the importance of tangaroa and the mauri of the moana and the interconnectedness of these spaces. And they say, foundational understanding of Te Ao Māori, and in this context Taranaki, is that our taiao is intimately interlinked, ki uta ki tai. The journey of wai as it falls from the sky, flows over land and out to sea. Part of this journey in Taranaki is the flow of wai from our tupuna maunga, which transports iron-rich materials through our awa to the moana. The iron in our whenua and sand goes back to when Turi, captain of the Aotea Waka, was told by Kupe of the whenua that was termed as one kakara, the soil that was sweet-smelling and therefore fertile for growing kumara. The volcanic properties of our whenua have been long recognised as important from our cultural identity, and the iron-rich sands and benthic material in our moana are vital to our taonga species as well as our coastal and oceanic environments. So I just urge you to return to some of that material that's been provided to you as you're assessing what exactly kaitiakitanga is in this context, and in particular to the iwi of Taranaki. They have gone to some effort to provide that to you. It's expressed through ngā raurutanga, it's expressed through ngā ruahinetanga, and they have done their best to collate all that for you in this short period of time. The final matter I'll end on is just that you did receive some comments from Minister Tama Pōtaka in relation to the application, and I would put it to the panel that it is significant that while being neutral on the application, he did draw your attention to a number of the treaty settlement mechanisms that have been raised by the iwi and Te Ohu Kaimoana, including the fisheries settlement, the Ngā Ruahine settlement, Ngā Rauru settlement, and Ngāti Ruanui settlement, as well as Taranaki iwi. That is important because I think it goes to the intent of Section 7 and the considerations that you have under the EEZ Act. It is important to the Crown, and this letter in my submission is an indication of it, that treaty settlement commitments are upheld, that the integrity of those settlements are upheld, and that is why they have provided for this process in the Act of Ministerial Comment. And, you know, in particular, Minister Pōtaka recommending that the panel have regard to those matters in terms of your decision making. So that's probably the point I would conclude on, other than to thank you for your time and effort in this very fast moving process.
That's a good point to finish on, Mr. Walker. Anyone else other than the applicant wish to address us?
Yes, just briefly on a couple of matters. John Commissaris for Environmental Defence Society. I'd just like to address briefly question 2 and question 4, noting that they've been well addressed by other council. Just on question 2, which is about the discharge and deposit in the CMA, just to refer to the panel to footnote 6 of EDS's original comments. That's the where EDS's submissions and previous submissions and joint memorandum of council that Mr. Enright referred to, that's where that can be found, and that explores the issue in more detail. And just on that point, about the distinction between discharge and deposition in Section 15B and Section 12 is just to note the slight hiccup that the definition of discharge in Section 2 of the RMA includes deposit. So enjoy. On question 4, which is around the relevance of feasibility, support what Mr. Anderson has said in relation to that, and just refer to paragraph 12 of the written submissions, and there's a little bit of discussion about the ways in which feasibility is relevant. It's relevant not just in terms of whether the benefits will materialise or whether the conditions are appropriate, but it's also about whether the applicant can feasibly manage its impacts, and that goes to what sort of conditions need to be set and whether a bond or performance conditions need to be set. So I'll leave that there. Thank you.
And there's no one noticed the stray hand in the air. Yes.
Thank you. Just following up on that point that you asked about an appeal, and I may have spoken too soon. I thought, given Justice Bolt's watertight, excuse the pun, decision, that the attorney may not have appealed. The attorney has appealed, and that appeal will be heard in June next year. But of course, if the panel would afford me the opportunity to make the trite submission that, of course, it is currently the law, and so that appeal won't be determined before the panel has to determine this application.
Well, we have enough to decide without having to decide what's making it.
Indeed, sir.
I've got one question again for Tokum. Just to complete, given you were obviously part of that process, Te To what extent do you think Justice Bolt limited his remarks to the Fisheries Act? So, in your mind, what, if any, weight is there for the wider framework of treaty settlements, given you were a part of that process?
I actually wasn't. I'm sorry, that's why I wasn't clear on whether they had been appealed, but I'm happy to answer the question because I have obviously read the decision now a number of times. I think
I'm not the only one who needs to speak up. Can you just
Sorry, sure. Is that better? So I would say two things in relation to that. One is that clearly this was in the context of the fishery settlement, and His Honour does go into a lot of detail about the importance of that settlement for sort of broader settlements, it being one of the first ones, etc. But the second point I would make is that he doesn't limit his consideration of settlements or his comments, in my view, about the importance of treaty settlements and the integrity of those and the obligations of the Crown solely to the fishery settlement. So in our submissions we highlight sort of a number of comments that His Honour makes, dicta, from the judgment that, in my view, extend beyond the fishery settlement because he's talking about the Crown's obligations in the context of settlements more generally. And to pick up on my friend Miss Walker's submissions, you know, the somewhat arduous process of getting to the finality of those obligations for the Crown. So those are the submissions that I would make in relation to the breadth of His Honour's judgment.
Thank you.
All right, thank you. Ms. Maxina and Mr. Slifer, this is not the limit here at all, but how long do you think you would need to reply to these matters and anything else you want to add?
I think we will be relatively brief. I'm inclined to go with Ms. Inns's 4 to 20 minute range and indicate most likely towards the 20-minute end of that range.
Well, I think we'll take a lunch and adjourn. But we will resume. We'll make it full 30 minutes, so we'll resume at 1:35 and hear from you. Thank you all very much.
We agree with what?
Keep that earlier flight then.
That doesn't change any of the points that we talked about, does it? Does it?
No. So, but that's the 40% that they picked up. But
Just keep it
that's so the reduction in primary production over the whole settlement model is as follows.
1.9 versus 2.9.
1.9 and or 2.9 worst case. And that is also so that's where
So nothing's, I mean,
that's also so Cahoon, 2015, they talked about the value of reductions in microfiber benefits and the benefit component on the C4 in that shallow area of between 30 and 50. It was Mark James who picked up and just didn't get the DQs that so that's where that 40% comes from.
I think we've just confused them if we say all that.
So, I mean, and there's another, happens to be another 40% reduction when you look at the difference in over the whole sediment modelling domain of just the microfiber benefits flux. That's actually another 40% change from the standard modelling to the worst case model. It happens to be 40%. So
that's not what it's asking. No, and this is the issue that I have, is that having cabinet has been switched on enough to find that conflict very deep in the documentation. And so he won't, and he's picked up on the thing that we've said. Well, if you had evidence that you could use to assess this matter, then it would absolutely be a matter that you must assess.
So
there's no question.
So that flux has been assessed. So that's the flux to the seabed from primary production. The flux, the change in flux from stored organic material in the seabed has not been. That's the area that Seb Vanderbilt
But he's latched onto it on the basis that there's a number that says 40%. Yes. How can you ignore 40%?
Yeah.
We're saying it's the difference between 1.9 and 2.9.
It's a good, but that's not what
so
that
I
figure
think
that he's latched onto actually is about.
Distinguishing, the important point to distinguish here is that
there is the point you make is a valid one, but it's to one side of
so the flux of material from primary production to the city has been calculated and it is in a report.
Yes, but I think the answer is
We're talking about two different things.
I think the answer here is that they can't take further from that. They're genuinely interested. We've already said we can give the names to confirm the essence of what was given about the submission. It's just too hard to quantify.
Yes.
The same evidence, same supplement, you can tell them that's the figure. Here's where it comes from. You can trace it through.
Although Seb's evidence was about the store carbon in the seabed.
Understood. But it's another question that has come up on that same topic because it's about climate change.
40% doesn't relate to that. It's a different matter.
The 40% doesn't. Yeah, you're absolutely right.
Two quite separate points.
But it came up in terms of.
But I'm still about stored carbon. Yeah, I'm still about being
Yes, but you have to help. You have to help get him.
Right.
He's got carbon flux.
But he says that you've mentioned that it's a 40% increase. And he's talking about, he's conflating it, I think, he's talking about carbon release in the seabed. We're not. 40% is on benthic recovery primary production, and that 40% is clear from 1.9 to 2.9. It is not 40% in total. It is a very small percentage, increased by 40%.
Because that's not analysis, just told.
Oh,
no.
If I got that right?
Well, it all depends what scale you were looking at. If you look at the scale of the whole sediment modelling domain, the decrease in benefit production, as well as overall primary production, which includes benefits, is small, and it goes from overall goes from 1.9 to 2.9%.
Worst case.
Yeah.
But that's got nothing to do with carbon release
But
from the seabed.
isn't Morgan's point the right one though? Trying to answer this on the fly with a conversation between you three is the wrong forum.
Between us.
Yes.
It's confusing. It's confusing.
I feel like this is a standalone zero page.
We kick for touch. We just. Yeah. I agree. 100%. 100%.
Because if I'm trying to say, oh, 40% here comes from that, and there's another 40% which is the 1.1 difference between normal modelling and worst case modelling. It's just going to
And I attest that I comply with the expert witness code of conduct.
It's an evidential method, not a legal system.
And it's only a one-pager.
Yeah. And it will be clarified in part by the expert conference which took place on Monday, and also by SEBS, if you want to use part of it.
Yeah. That's end of conversation.
So the question is
Well, we've got information, we've got SEBS sitting.
It needs to be.
Well, we need to provide SEBS guides and back to recycle.
It's easy. We should be able to get it to the next one.
Done. Let's get out of here. It's too hot. Yes. It's just so uncomfortable. Oh, no, it's warm in here. Don't you reckon? It's not as bad as it was.
There's been a lot of hot air. Stand out or yes, you? Yes.
Yeah, okay. Why don't I just, oh, if you had to, potentially change. Okay, all right.
How's everything going? Good. Oh, wow. Sorry. Is it a bit too warm here? Do you want it a bit more? I think I put it oh, yeah. Especially because it's the glass wall, the sun. Yeah. I think it's cooling down. Okay.
Yeah, excellent. Thank you very much.
So it seems to be some booming in Wellington, is it?
Well, seems to do a bit today, so just to soil and all sorts of things.
Boost for the business.
Yeah, well, yes, yeah, I think you were with us.
If I can't phone stop.
It's hot. Oh, yeah.
It's one of those.
Reminding me of
Cool. 2 minutes.
Plenty of fresh air.
Raining.
Unlike it either.
I talked about my theory about, I think everyone in Wellington has syndrome if we go like that people go, yeah, they can't just do well, that's, I don't know what this bracing makes it like. 2 months of us.
Yeah, I couldn't go back either. Once you get out, you're like, oh gosh, it's so peaceful. I can hear everything. It feels like someone's taken like hair mask. No, that actually sounds
It's good, but it can. That's my point.
by anywhere else in the day.
Yeah.
Yeah.
I think we can make a start, Ms. Buxey and Mr. Slyfield.
Thank you. I think I only have 4 topics that I wish to cover in reply, and I will be relatively brief. I should say that I'm really just not going to restate things that I think have already been well thrashed out in the written documents. It's addressing things that have come to the fore over the course of today. And I think I'll move from the sort of easier side of things to the more complex side of things. So the first point I want to start with is the argument that's made about habitats of particular significance for fisheries. Some of the other parties, as you've heard, are asserting that that the lack of formal identification of such habitats is not determinative. And all I wished to do on that space is alert you to the case law that Tallies and Seafood New Zealand referred to, in particular the Unison Networks case. It has been referred to in their submissions, and some of my friends relied on that in making their comments. It's been referred to on the basis that it supports a proposition that lack of formal identification doesn't preclude ad hoc identification, if I can call it that, on an individual application. The point of difference there is that that was an RMA case dealing with a type of RMA identification, namely outstanding natural landscapes. And in my submission, that's a rather different proposition than the present circumstances, where the route by which the panel arrives at consideration of habitats of particular significance to fisheries is via the requirement in 59.2h to take into account the nature and effect of other marine management regimes, which in my submission is sufficiently further removed that the type of approach exercised in Unison Networks does not necessarily translate to this setting. And I think it begs the question whether requiring you to make an assessment whether there is or isn't a habitat of particular significance is getting into what the Supreme Court described as the minutiae of other marine management regimes, rather than looking at them at the level of nature and effect, which is what you're required to take into account. So that's all I was going to say on that topic. The next topic is coming right back to question 1 and the status of DMC findings. I think it's self-evident. No one is pointing at the 2014 DMC decision, but there are a number of parties pointing at the 2017 DMC decision and saying you can and should have regard to findings of fact, and in fact asserting in some cases that in making your decision it's necessary for you to explain, if you depart from findings made by that DMC, necessary for you to explain why you've departed. In my submission, that's not legally supportable as a starting point, and I won't go into a great deal of detail because it's already stated in the written submissions, but the 2017 DMC decision was quashed, the application was subsequently withdrawn, and I think the reason that this has been proffered by other parties is essentially one of efficiency, where they quite rightly observe that DMC held hearings over many months, had a luxury of time that is not available to this expert panel, and that sort of elevates in some fashion the significance of its findings. The problem I ascertain with that whole proposition is, in my submission, you cannot look exclusively at the record of decision. If it were possible to simply look at the record of decision of the 2017 DMC and say, well, we've reached a different view on this, then that might be one order of reference. But in order to actually compare and describe a departure from what that 2017 DMC did, you would have to go far deeper in my submission. You would have to understand what the evidence was, and that included over the course of hearings, which, as you know, were the subject of where cross-examination was permitted to occur. And so the sort of carrot of efficiency that has been dangled in front of you in my submission is illusory, because in reality, if you were to undertake the task that has been put upon you by other parties and say, we're departing from a finding of the DMC and here's why, you would actually have to get into a level of detailed analysis that I don't think is available to you in any reasonable sense. So I submit that's not the correct starting point. There are no findings of fact from the 2017 DMC that remain, and I think the only point that I need to add to...
Can I
Yes.
ask you to pause there? When you say the findings of fact don't remain, do you mean because the decision was quashed, they no longer have any legal significance or effect?
That's,
is that what you mean?
It is, yes.
But there was no challenge, was there, to material findings of fact in the appellate proceedings? So that no appellate court addressed findings of fact and said that they were unfounded or unjustified?
I don't... That's not a simple question to answer, sir. And the reason I say that's not simple is because certainly the Supreme Court went so far as to say some findings of fact were these, and we, in our minds, the combined justices of the Supreme Court, cannot reconcile other findings that were reached on the basis of those facts. And so in the appellate courts, there was quite a detailed examination, certainly in the Court of Appeal and the Supreme Court, of what I would describe as matters of mixed fact and law. But I caution this panel against treating any record that forms part of the Court of Appeal or Supreme Court decisions as what it has been described by some of my friends as an endorsement of the findings that were made by the 2017 DMC. That comes out of the Tallies and Seafood New Zealand submissions. They say the Supreme Court endorsed these findings about the degree of adverse effects on certain sensitive environments. And in relation to that, I say the 2017 DMC was the last body actually charged with making factual findings. Every other body since then, the High Court, the Court of Appeal, the Supreme Court, were tasked with determining points of law on appeal. And so none of the references made by the higher courts, the senior courts, to findings can be taken as endorsements per se, because none of those higher courts heard the evidence or tested it. Or
And they weren't asked to consider
no, no. And dare I say, by the time matters arrived at the Supreme Court, it was sufficiently far removed from what had actually played out at the 2017 DMC that the task before the court was a very difficult one, and I think that's evident from the variety of opinions that their justices expressed.
That's a fair point, I think, that the Supreme Court. I thought you were going to say far removed from reality.
No.
Wise of me or brave.
I would not be so bold.
But, I understand your point.
Yes.
Just because the court didn't say we don't agree with that finding, they were never asked those questions.
No.
Only the findings of fact was merely background.
Yes, and predominantly they were relying on the record of decision.
Yes.
And I think it's fair to say it's self-evident that the record of decision had deficiencies, as the senior courts found.
Yes, no, I appreciate that.
So I think then second to last point is the vexing question about discharges. And I can't pinpoint which of the other participants here it was who referred to it, but in one of their legal submissions, they referred to the Environmental Law Initiative and Attorney General decision. And I commend that to you because the Environmental Law Initiative and, sorry, not Attorney General, Canterbury Regional Council, which is 2024 NZHC 612, at paragraph 95, summarises exactly the point that my friend Mr Conway for the Regional Council made, which is that in an RMA setting, the traditional view, and I would say more than traditional but well-established jurisprudence, is that the point at which a discharge occurs is wherever the discharger loses effective control of the substance that is being discharged. Now, I think here it's become a little bit more of a distraction than it needs to be, this focus on deposition, because there is absolutely no suggestion by TTR that deposition is beyond the frame of your consideration. In other words, as a consequent effect of the discharge, deposition is plainly within the matters that you must assess as an effect of the activity, and that is regardless of the CMA boundary. So we're not dealing with a situation where the requirement or lack of requirement for resource consent is precluding a relevant impact or effect of the activity from being contemplated. Quite the opposite. The sediment plume, for a substantial part of it, will be within the CMA, and it's been very clear that it has been assessed in terms of its effects in the CMA, and the parties disagree about what those assessments conclude, or what conclusions should be drawn from those assessments. But it's not the case that deposition is being swept under the rug. Deposition is before you and is able to be considered. And my submission is simply, there is no purpose then served by this panel stepping into the realms of making a determination about what further resource consents may or may not be required. And I would go one step further and say it's doubtful in my submission what status a finding by this panel on that matter would have. And I was surprised that my friend for the Regional Council, he didn't invite you to go there, but he said it wasn't precluded, effectively. That's my rephrasing of what he put. And I suggest to you that that puts the Regional Council in a spot of bother, because it is its statutory function to be the regulator in the CMA and apply its regional coastal plan. So if it forms a view that is different from the view that the panel forms, and there is a record in the panel's decision, it begs a question: what is the status of that finding by this panel?
I must say, for my part, it never occurred to me, or I perhaps it should have, and I might have to think about it, or we might have to think about it, but the panel's finding on that sort of question, or had any binding effect, might be influential in respect of other panel decision making. But I can't for a minute think that the Environment Court will pay deference to, with great respect to my colleagues on the panel, pay deference to our findings on the panels. I mean, if we make findings on questions of law, then others will consider whether we've got that right in what we've asked. But does it really come down to this, that this question of discharges, for our purposes, is essentially a factual. What is the effect?
Yes.
Where will the sediment go? What state will it be in when it reaches certain points? and it really doesn't matter whether it crosses some line, artificial line on the map or in a regulation or a plan. Our concern is what is happening to the environment as a whole.
Yes.
And that we shouldn't worry, and this is, I think, your point, we shouldn't worry about the legal implications of that because we don't need to consider it.
Exactly.
Is that really your submission?
It is. It's entirely a factual question, and it's slightly further afield. But there are a raft of other regulations with which TTR will have to comply in due course if it gets its marine consent, and they include maritime transport regulations and craft management documents under the Biosecurity Act and so on. It's not really for this panel to be thinking ahead to all of those and saying, well, without that, you can't undertake the activity, which comes back to the sort of feasibility debate that's been playing out. And I don't think I need to say anything more on that front. I agree with you, sir. It is fundamentally a factual assessment for this panel, and where the law passes between one state and another is not really your concern.
Well, thank you for agreeing with me, but I was trying to understand your submission. So
right.
We haven't.
Well, I agree with myself in that case.
I'm pleased to hear that, Mr. Chairman. But we haven't come to any view on this one. We just wanted to clarify that is your submission.
It is. Yes. It is. I think the only other matter that was on my list of matters to cover was I did say that we could come back to Mr. Kemball's question about the source of the 40% figure that you pointed us to in the CCAP document. The answer is a little more complex than one I should be giving you as a legal submission. And so, depending on the panel's view about the offer that I made earlier about receiving a piece of supplementary evidence that picks up on the submissions I made to you about climate change matters and carbon flux and so on, my respectful proposal would be that that's a matter that we could trace through where did that come from and what does it mean better for the panel in the supplementary statement that is being proffered.
So could we do that under section 67, which is a much less arduous procedure? We're going to draft the minutes and just get somebody to make a request of you. What vehicle should we use once it's
I confess I hadn't even turned my mind to that aspect, sir. Bear with me, and I'll just remind myself. 67.
We can ask the EPA to request further information rather than issuing a request for information.
Yes.
Formally ourselves.
Yes, I think that's the appropriate vehicle for that in my opinion.
Kelly's confirms that she's a much higher authority
than all of us.
So thank you.
Thank you.
We will adopt that.
Thank you, sir. And I'll just check my notes, but I think that covers everything I wished to say. Yes, that is everything that I wished to say. Thank you, and thank you for your time.
Thank you. I want to say, on behalf of these two rows of participants in this process, how much we have appreciated the work that you've all done. It's been interesting to me, but no surprise to those of my colleagues who spend a lot of time in the environmental law environment. that the quality of the written and oral submissions has been excellent. And we have so many lawyers in the room addressing us on these topics and have them universally performing at the highest level has been really satisfying and helpful. So I do thank and congratulate you all on the standard of your work, on your diligence, and particularly given the time constraints for having turned it around so quickly. We really appreciate it. It's been a very worthwhile day for us. Also important to us in our procedural aspects is to recognise tikanga. And I want to acknowledge Haimona, who has come all the way from Taranaki to open and close the proceeding for us and endure a bunch of lawyers talking for hours about arcane subjects, which I'm sure he is interested in, but not that. Haimona, we appreciate you making the effort to come all this way to us. Would you please close the proceedings for us?
Tira tēnā tātou, Mr. Tūpui Tūki. Kia tātou katoa e mihi ana, kia tātou koutou e hāpai ngā atuatanga, e tikana ka mihi kia tātou. Probably the only not lawyer in the room, but the pā marae man that holds the TTR really well and pretty good at digging hole for the hangi. So kia kauaki nei ngā kōrero o taku marae ake, Ngāti Roenui ko haramai nei i a ngā rauru, a ngā ruhinerangi, te mātonga o te tēnā tātou. Be wrong me not acknowledging the haukainga, Ngāti Whātua o rākei. Mihi ana ki a rātou. Me ki ngā tōpuni o tukeriri, te mana whenua o te moana nei, e tikana, te haukainga, e mihi ake tēnei rāwa o poharamai nei kia mihi ana kia koutou kei te huari, kia koutou kei ngā mana, kei ngā ihi, e mihi ake nei. Kia taupiro nei ngā manaakitanga o te waihinga o ki nui a tātou. Kia paiheretia te rangi Māori, kia tutuki ai ngā wawata o kui mā o kuro mātira, o te iti o te rahi e noho tahini. Kuritia mai te tāuru o te rangi kia tīna, kia uena, kia toko te manoa ora. Tīna toko te manoa ora kia rangi e tūnei, tīna toko te manoa kia papa e takotoni. Tīna toko te manoa ora kia tongaroa, mā kiu nei te huinga tangata e noho tahi nei, turu o ti wakamaua kia tīna, tīna, hui e, tātai e, tēnā tata.
Kia.
It's only, well, it took us ages, an hour and 20 minutes. The overnight. Well, I'm not far away.
You're supposed to listen. You're supposed to listen to that conversation. It's better.
Spot on. It's great.
I'm always like, we have everything on that.
Oh, that's all right.
Does it say 4L1 or something on it, does it?
No, it might look like
That's good. Well, it's great. It's great. But not just in terms of creates a you all can without knowing each other.
Yeah, I think they might need to do a distribution.
Oh, exactly. I think all it's doing is making sure that Buddy's not hung out to dry. He's out, he's writing a statement of evidence. We just want to make sure that Luke wants to make sure that he's aware of the factual matrix. So what he says is A, fully informed as he can be, and B, he doesn't say something that's incorrect. Yeah, that's a good idea. That's a good idea. Let him form his own view on it. It's good thinking.
Yeah, he's great.
Inclusive and let everyone be heard.
It's more just stuff in there. Yeah.
So considered.
Some sort of yeah, I can hear it. Brings it alive. I think it's stopped. I think it's should itself. Is the technical term. Let's go out
Look at them go!
I need to sleep first. You and then get a lot more experience than who can be get a money so second time I completed court.
I'm still giving you a pretty well.
You made the right call?
Yeah.
Well, that's right. No, I didn't manage to get back to Perth for 11 days, so hell, yeah. We're really thrilled to hear that I was there for 1 weekend and going. My Sunday dinner. So on we go. I think so, but I've still got a couple of alarm bells in the back of my mind anyway about what they might call us together on.
It's more information.
I won't start with a few, but there's a couple of major clubs that haven't been included. I'm not sure with the YE decision helps us out on that or not. I think it does. How that is. It's not over yet.
You know? But it's just like, it's just the whole well, some of those guys it's a bit from the agent. Yeah, that's a good question. I want my shareholder. So how I can do that number, right? No, I was
You make 4 days.
I will. I mean, I know the problem is, of course, the jury. Probably infamous already. By who? One of the applicants, probably. Anyway, it was they're seeking indemnity costs against the corporation. So this is what the corporation kind of like reacting in kind. It's just like oh, it's yeah. This and that.
I'm like, well, that was great.
We just got some.
Anyway, I might see it here, or I might think better of it, just because.
But needed, so you can bring such a run, so it's like really hard. Yeah. 40 stages. You'd need 5 juniors. Yeah. Probably done with hearing together. Safe travels. We'll see you again. Honeys? No. Yeah, no, it's good to kind of just organise it like this. It's not good for a while. Yeah. 2 days. Yes. Like it's all the rest of the week, so I'm going to make a case for the conference. Yeah, Friday. What are you doing? Oh, I'm going to copy one. So what are you doing? Oh, I'm going to
That's all right. That's all right. We're just saying.
Oh, so they. Oh, so look at this. Sorry, but we can go. I don't know about moving it, but.
See you later, Alison. I'm going to head away. Safe travels. We'll see you soon.
Bye-bye. See ya.
But then there's just this cake.
Paul, are they able to plug into the screen they're going to do something to that?
Not sharing it, so.
It's just them, so they're doing it and they're just going to plug the screen in and just see.
They don't need any
They just need to plug it in.
Will it go okay if I start camera?
Yeah, that's right. Yeah.
Make sure it's just as long as we still keep this one.
Yeah, okay. Don't worry about all this other stuff. That's just for the.
Oh, can I be cheeky? Can you go outside? I just need to take this out.
Okay.
Sticky tape.
Oh, yeah. Just take this out.
This is professional definitely.
Yeah. So, we're checking it out.
Okay, thank you for those recordings.
Keely, could you make contact with Nat and Hilda and see whether they'd be available sometime at the same time? Also, they just important Yeah, just let us know what time.
Yeah, event is finished. They have the recordings. Yeah. So they're just going to sit there quietly and have a brief, but they don't mind us packing out once we can. Don't make noise, too much noise. Okay.
Hey, Doctor, how are you?
You guys want
No, I actually haven't seen any emails because I've been sitting in this hearing, but the hearing has finished, and I was wondering if we have time this afternoon to
Thanks, Alison. I'm going to take off.
Okay.
Thanks for your help. Right. You're on to these other couple of issues. That thanks.
Morgan and I will make sure that we cover those off. Some questions going to come through from
Okay, cool. I'll
from EPA and some.
Oh, yeah. I'll go on that. Cool, thanks. The light has ended, right? The light? Or is it still going on?
No, it's finished.
Okay.
Oh, I'm just getting the stream.
Yeah. When I'm walking on the street. And you've passed on your